Huh? How many?
Lordship, 8, no, total 9, Lord. 8 are covered by your Lordship's order. One is with regard to seeking extension of time for
You will tell us which is what is covered and what is the order,
Definitely.
right? Only on that condition. Yes.
Right.
Huh? Yeah, what is this? Mr. Rao, we hope that you will have notice of all these petitions because we cannot take him by surprise. You please supply him a copy. Tell him what is it. Yes.
Mike, not interested. It's a company appeal.
IA what?
IFL is changing of name, Lord.
27-9.
Your Lordship, arbitration application, Lordship. Kindly push for lunch motion, Lordship.
Why? What is the urgency? Lunch motion.
No particular date was mentioned during last hearing,
No,
Lordship.
so therefore lunch motion, right? What has been done in arbitration application?
Notice served, Your Lordship, and refused by the opponent party, Your Lordship.
What do you want?
Sole arbitrator, to appoint sole arbitrator, Lordship.
Sole arbitrator? How? The division, this is single bench.
Yes, Your Lordship.
Then Mr. Don't make a mention, this is division bench. Most inappropriate, right? Yes.
Much obliged.
May it please your lordship.
Yes.
BSF Jawan, my lord,
Ah.
under brain operation Kim's Hospital. Writ appeal filed after the reinstatement was ordered well and single judge and vacate stay petition is pending.
Ah.
Now, if writ appeal is disposed of, stay is vacated, he may get the governmental.
No, but could you please file an application for urgent hearing? We will consider.
Register letter has been given and served on the standing council and also medical
Application for
papers are filed into the record, my lord.
You have to file an expedite application, sir. We have been saying this every day.
I filed
File an application.
I filed memo saying that unable to file the petition, we cannot obtain signature from him. He is in very bad condition. I filed medical papers into the record.
for
Medical
fixing date of early hearing, you don't need an affidavit, right? But for fixing a date for hearing, they are not required to file an affidavit. You file, tell him, you file a memo.
Filed.
Yes. We can't hear Mr. Final hearing matters like this. We have been telling you, ask Mr. Rao, please explain it to him. Yes. You have to file an application for early hearing of the petition by assigning reason. That will come up. We will fix a date as per our calendar. It like the motion hearing we cannot fix. final hearing. Everybody yesterday who has filed a petition will say today like memo, it be heard today and certified copy delivered to be my residence at 7 p.m. Is this the way court run? Yes.
If your lordship so permit me,
Like,
after
we don't-
23 years reinstated, my lord. After 23 years reinstated,
We
in
don't
medical
know,
emergency arose.
We don't know. We hope that we have made ourselves clear to you. If you have not understood, please ask others what they are saying. You want final hearing, this can't be done by memo. Yes.
Medical admission, today.
Today. All right, lunch.
IA for expert hearing file mela
Oh,
2000.
see, tell him that's what exactly is you are required to do. Tell the other council. This is what, we'll list it on consideration for 510. IA for expedite petition, not anything else. What is the matter?
But the service regulations are under challenge mela rules. Mela, they have changed the regulations and giving promotions to the ineligible candidates mela. That was a challenge.
This 23 matter, right?
Pleadings have, no, 22 matter mela. Pleadings have been completed
But,
mela.
Are you aware since when petitions are pending?
We do it.
Yesterday, 97, 98.
Some
The
day.
case we have heard and closed. There's absolutely no justification, Mr., for hearing 2023 petitions out of turn and granting because client is after you. What happens to 97, 98? The poor man must have forgotten that I had filed a petition in the High Court. Yes. Saturday. That's no emergency, nothing. You are being hanged. No emergency. Is being demolished. No, this Saturday. Day after. Tomorrow, in fact, tomorrow.
Two connected writ appeals, my lords. This honorable court has heard it and reserved it, my lords, but it was released at a later point. of
No,
time.
no. I have never done it, Mr. Don't make such an accusation.
No,
I have
not your
never done it in my entire life that after hearing a case, I have reserved it, released it. This has not been done by me. Don't tell me.
No,
This is
apologies,
wrong.
my lord.
It's
Apologies.
actually incorrect. Don't make, we will ask you to which case I have heard and which has been released. Tell.
No, apologies. my
No,
lord.
tell us
Earlier,
which case?
earlier first court, my lords. Deep apologies.
Don't make incorrect statements.
Apologies.
We are trying our best. We know how we are managing, right? And the councils who argue, they know that how we are managing.
Oh, deep apologies, my lords.
Don't start with an accusation. File an application, go to that bench which had released the matter. We are not responsible for anybody's release. Yes.
One submission.
My lords, this PIL was filed.
What
The
PIL?
appointment of President of the State Consumer Commission. My lord, the post is not filled up. The state took time that it will fill the post, but since 9 months the post is vacant, my lord. Any date may be accommodated to your lordships. A date may be given, my lord.
What they had filed, asked for time to file counter, right?
Counter is filed, my lord.
He filed.
Yes, my lord. They sought time that within 2 weeks they will fill the post.
All at 3rd October.
Obliging.
Yes.
Subject line permission, my lord, is a PV.
Yes.
My lord, I filed. my lord,
Item 1.
I appear for the petition.
Yes.
The present.
Yes, Mr. You want to say something?
the one IA.
We are unable to hear.
Urgent hearing. My lord, there is, my lord, absolutely there is urgency. Your lordship have it, my lord, that IA petition tomorrow, my lord, your lordship consideration. Your lordship consideration. The urgent. hearing
Which IA, sir? We are not able to understand you.
My lord, I filed, my lord, one IA for urgent hearing. That is, my lord, number, your lordship may have it tomorrow.
Which case?
My lord, matter pertaining to, my lord, giving spouse points and
Huh?
situation points. My lord, that was,
We have heard it and passed orders. Yes.
that is, my lord, modified your lordship, my lord, that order.
Ah.
Now 60.
That doesn't mean that it stays modified. We should hear it that very day and supply copy to your residence. Doesn't mean that. It will you make an application for urgent hearing. It will be considered. Yes.
I filed, my lord. I filed, my lord.
Where is it? There is somebody has to hand over that this thing. When have you filed?
My colleague.
I get 10 of 2023 millard. Sorry, millard. My senior millard. I get 10 of 2023 millard.
IA 10. Which case you have filed?
That WP number 3962 of 2020.
You want listing of that case.
These are
Listing of that IA, it will, the case will not be listed. That IA will be listed on 1610 for consideration.
started me clear
No.
the respondent
There are
the
better
schedule
things to
was
do.
fixed Millard already.
Mister, there are better things. You have like, your senior is arguing through video conferencing. You are also picked up, right, feeling encouraged from his behavior, right? Don't do it.
Started maybe. The schedule was fixed.
No, this is our discretion. We have done it. There is no justification when 97, 98 read petitions are pending. We are not offering here explanation to anyone, right? This we have passed an order on your mention memo. If you are aggrieved, go northwards. Travel northwards. This. Say that, file SLP and say that High Court should hear it today, Sunday itself, and from 10:30 till your senior feels exhausted and dictate judgment. Get an order like that. Yes, from Supreme Court. We'll do it.
May it
Yes.
please your lord. The writ appeal is filed against disposal of a writ petition at the admission stage.
1 minute. One. Yesterday's. Yesterday's. Fine. You tell the councils that it is ready.
May it please your lord. The writ appeal is filed against a disposal of a writ petition at the admission stage without notice to the writ appellant herein. Lordships, the appellant had complained about the encroachment of the fifth respondent, of the first respondent writ petitioner on the property of the appellant. Thereafter, there was an order by this honorable court to consider my representation in accordance with law and take appropriate action. Thereafter, an action was taken and he was asked to, the first respondent was asked to produce his sanction plan. That was not produced before the authority. Thereafter, without notice.
What do you say? No, instructions are that he has been not heard. Are you in a position to tell us that notice was issued to respond number 5? That he is aggrieved by. But you will also be heard, Mr.
No, your lordship, the difficulty is the learned single judge has foreclosed the right of the municipality to take action against the unauthorized encroachment. My contention is that the illegal construction itself is the unauthorized encroachment. He has encroached by illegally constructing into my property. It is deviation of the sanction plan and as well as it is an encroachment onto my property. They cannot be
Let
dissected.
it be heard afresh. There is no point in keeping this writ appeal pending. This intra-court appeal, I'll have the
May I
presence
say
with
this?
consent.
I am the writ petitioner.
We thought he is the writ petitioner.
These were TSHC.
Then,
Uh,
so then has it been passed without hearing him?
the admission stage it was
Order.
disposed of, but if I may submit, it was not a positive order in my favor. It only directed the GHMC to.
No, you are an encroacher. The learned single judge has foreclosed the right of the municipality to remove encroachment.
No, but it's
Then why did you implead him? Why did you,
He's complaining.
we will set aside, Mister, we will set aside the order and you delete the name of respondent number 4. Thereafter they say order, you can get it from the learned single judge by showing that same order be given to me. You can show.
in the interregnum there may be status quo, my lord, because the impugned order in the writ petition directs me to remove the encroachment. It is my case that I constructed with the building permission in 2013. He wants
No,
to, he
Mister,
wants,
the short point is that how can you have impleaded him as a respondent? He has not been heard.
No.
And the grievance is that the right of the municipality to remove the encroachment has been foreclosed. How can this be?
no, while setting it aside, I'm only praying for your lordships to direct them to maintain status quo, the GHMC, because it's a civil dispute essentially where.
You file a suit for injunction.
No,
Every
that
time
is for
jumping to the High Court, setting aside means,
No, my lords.
Mister, 1 minute. Do you understand what is the effect of setting aside of this order? The writ petition revives. You go status quo, do whatever before single judge.
Until it is heard, your lordship may grant me, protect me until then that period.
No. How, when we are setting aside only on the ground, then What will, if we ourselves decide, then what will learned single judge do?
Until it's
You
heard by
will, no,
the judge, because
you want us to maintain status quo and let the writ petition be pending for 25 years before learned
your
single
lordship will
judge.
fix a date.
You will argue it in sometime in their 2049. By that time, you will be designated
No, no,
senior counsel of
Your
the
lordship
court.
your lordship said
We will be gone from this world 2049, and then you will say that the status quo is operating. He will also leave somewhere,
your lordship-
his client.
Yes, sir.
Everybody. Arey, Mr. Lighter when I am saying lighter when you should enjoy the humor. There is nothing to be so serious about everything, right? Nothing. Why you
The
are?
interregnum, if they demolish, I'll be put to hardship.
No, nothing. They don't do anything. These people are known for their inaction. Pollution Control Board, local bodies, they don't. That's why so many petitions are filed. They don't do anything.
No, they are doing much more than they can in this case.
So till the matter is taken up by the learned single judge, don't demolish, Mr. You tell your clients, we are not passing any order, but you tell not to, right?
They have already.
No, Mr. You cannot move a mention memo like the one is moved before us. You move mention memo tomorrow before single judge and say that please give me interim order. These people are demolishing.
Similarly, single.
I don't think, we don't think that the moment we sign this order at 3:30 today itself, the construction will be demolished. We don't think.
Because they are
And in any case,
The first writ petitioner's husband is a DCP of traffic, your lordship. That is why.
that's all. Who will enter? You will stop all the traffic going to that your house. Nobody can come. Signal, you will put a red signal. But their staff and encroachment, this thing team cannot reach your house.
civil
For
dispute.
2 years, we have been. Yes.
It's not worth it, Mr. We are spending so much of time. It's not
Very
worth it.
ungrateful.
In this intra-court appeal, the appellant has marked the presence with consent of the parties. He is appearing. Oh, this is very good here. Without this filing a caveat, everybody appears. Very nice. So, yeah, what is, we are inclined to condone the delay. What do you say, delay? Heard on IA 1 of 23 reasons assigned duly supported. You have that order. IA is allowed. 1 of 23. No, 27th, Mr. 27th September for orders on admission. Yes. Yes. Yes.
That's interconnected is also filed. Technically, it has to come off.
No, you tell about this case. What have you challenged? Demand notice under 13(2)?
We are challenging NPM allots because during the COVID period of 2 years, NPM allowed, there is expression of the NPA by the bank. Because during the period of 2 years, MSMEs have really given a liberty.
No, this is, read the prayer clause before you proceed on the lecture on the subject. Please read the prayer clause. 19/7/23 is the order. Sale notice.
Sale notice.
By now you are practicing here only, Hyderabad, right? So you know the view of this court. There is no point in arguing. This Satyavati Tandon, we are consistently following file and appeal.
My lord, sir, in this case, there is one technicality.
Whatever. Appeal. All technicality in appeal.
My lord, we have filed an essay, my lord. Essay I have filed.
Then what?
Got an interim order. I paid the first installment in essay. I am not on the bill. I filed the copies of the essay order also.
No. Against the order dated 19/7/23, you have filed essay.
Essay, my lord. I have given the order copy also. At page 18, I have the order copy of the essay, my lord.
Essay.
Yes, ma'am. Interim order of the appeal again.
Page
18, madam. 19, madam. In fact, 18.
19.
18, madam. Copy is
349, no?
Yes, ma'am. That is also filed, my lord. I have paid the interim order. First installments of the interim orders.
Then?
Problem here is,
No. One minute. So you have challenged the validity of the order dated 19/7/23.
Yes, ma'am.
In a
Before that,
listen, the problem is, Mr. that we have to pass orders. You say anything, but that doesn't matter. If the bank listens to you, give an order and sign it and give it to them. But that doesn't happen. Our order matters. So therefore, you have to listen to us. We want to be clear on facts. On against order dated 19/7/2023, you have already filed, approached the debt recovery tribunal by initiating proceeding under section 17, right? In that proceeding, stay has been granted. And again, you are challenging the order dated 19/7/2023 in this rate petition. So a query to you is whether it is permissible to do so, to challenge the same order in multiple proceedings. You could very well file this writ petition under Article 32 also against this order, if that is permissible. Which law says that same order can be challenged in different forums?
my lords, my prayer is, my lords, on 31/3/2021, they made me an NPA. That's what I'm challenging initially.
We don't decide. We are not cost accountants. We are not financial expertise. We don't issue certificate that no, the account can't be declared NPA under Article 226. We don't have any sort of an expertise. None of us have degree in finance or accounting.
My lords, I'm not on the chartered accountant or the backing regulation, my lord. When the MSMEs, RBI said all MSMEs has to be given a liberty and time to.
You are challenging the sale notice. Why don't you understand? This first part of the prayer goes 29/7, you have already challenged in a petition. See the prayer. That's why before we told you that before giving lecture to us on SARFAESI Act, you should see the prayer. So What can be? It can't
Lots.
not the presence heard on the question of admission. In this writ petition, comma, the petitioner inter alia has assailed the validity of the demand notice and sale notice dated 19/7/2020-23 issued under the provisions of Write the Whole Thing Surface Act. Paragraph. Learn it. Accordingly, the petition is dismissed. Next.
My lordship,
Ah,
my lordship, this matter is covered by your lordship order date.
not covered. Where is that delay and latches? It's covered, right?
Yes, my lordship.
This.
It is covered matter, that is WP 21-268 of 23.
Ah,
Order on 29/8/2023, my lordship.
covered by dismissal, he is saying, right?
My lordship.
Covered, that you don't. I thought, how can be he so fair?
Where is the,
No, he doesn't know.
Yes.
This is the order, please.
where is the local candidate of Andhra Pradesh? He cannot be treated as the local candidate of Telangana.
No, we don't know whether he can be done or not.
My lordship, small.
Petition has been, Mr. Those persons had come. They give it, your petition is being dismissed in view of the order. Yes. Please see.
My lordship, small submission in this regard.
Give that order, then make submission. Yes.
Ashma Analysis, paragraph 6, page 9.
Ah.
When he studied for consecutive years,
This is the order. Yes.
My lordship, small submission in this regard, lordship. I am a local.
No. The fact is that you are a fence sitter who was watching the proceeding conveniently from the comfort of your home and has filed this petition. When were you declared as non-local candidate? 2/8/2023.
My lordship, I also filed a residential certificate issued by the concerned
No,
authority.
you were declared as non-local candidate on 2/8/2023, correct?
My lordship, I declared as a non-local on
2/8/23.
13/9, my lordship.
All Mr. Incorrect facts are in this thing. We don't want to
Para number
prosecute
7,
the
my lord.
petitioner for.
Para number 7, my lordship.
Mr. If the statement is found to be false, the petitioner will go to jail from here only. You be careful. Because this don't make, Mr. What we are allergic to is factually incorrect submission. And what you say, we take it very seriously. Everybody else, the first list was declared 2/8/2023. All of them were declared as non-local candidates. And those persons filed the writ petition, prosecuted it, and their writ petition was this thing decided by us on 29/8. And for you, there was a special case on 13th September. Special counseling was held to declare you non-local. We will ask you to file an affidavit then. Tell us, when were you declared? If these facts are found to be false, he will face consequences in law. You know it very well as a counsel. Which paragraph have you said that 13.9?
Seventh paragraph, Your Lordship.
Ah. 13.9, where is the communication treating you, telling you non-local?
As per the direction of this honorable court,
No. You have only said para 7. Where is the document to treat you as non-local candidate on 13.9?
I apologize, my lordship, I have not filed any such document.
Where is it? We are asking you to file an affidavit. File an affidavit.
I apologize, my lordship.
No, you please file an distinct document. We are giving you time. When will you file? When will you file?
This is happened orally, my lordship. I do not have any document with regard to this, my lordship.
This is petitioner is either petitioner or you have suggested him to make a factually incorrect submission. All of them have been treated as non-local candidates on 2.8. This is covered by this judgment. Whatever you argue, we cannot take a different way. You will have to travel northwards, right?
Much of
In this writ petition. One has to accept the reality, even if it is against you. What with this is our order, right?
Yes, my lord.
We cannot take a different view in your petition. All petitions we have dismissed on the ground of delay. And so far we have not come across any order of Supreme Court. What to do? The petitioner is an aspirant. Heard on the question of admission, mark it.
Lord,
Yes.
in this petition, Lord, the petitioner is seeking a direction, Lord, to the respondent authorities to consider the case of the petitioner in future counseling of the medical, Lord. Lord,
No, but under the rule you are dissent at.
Lord,
You have to challenge the validity of the rule.
Lord, kindly CH pen number 13 of the material paper, Lord.
No, mister, you have been allotted a seat in one round of counseling,
Yes,
right? In
29,
spot number,
2.9, she was directed to report a particular medical college on 2.9, my lord. The situations
you did not take admission, right?
did not take admission. Behind her control, my lord, behind the human control. Her husband, her father was admitted in a hospital, my lord. I filed the medical reports, my lord. And
Page.
Second page of the.
Hey, mister, you will have to challenge the validity of the rule.
my lord, they communicated through email, my lord. At page number 13, my lord, 13. You are not eligible for exercising options at this stage. Lord, see,
1 minute. See, our job is to tell you the rules also. Then to convince you that you are not this thing. This is your. We should prepare the case here itself, Mr. Counsel, together. We should prepare the case. See the rule. How do you draft the petition without going through the rules? I really.
my humble submission, my lord, it is stated by her. After receiving the above message, we could not report to the college due to personal health reasons. Rather, we tried to register for second round. But unfortunately, we are getting the below message of not eligible for further counseling. That is, unfortunately, that message was communicated by the authorities, my lord. She got a seat behind the women control, my lord.
20. Yes.
She was not permitted for further counseling.
Anything else?
My lord, in this matter, at least he may be considered for future rounds of counseling, my lord. Because
You have read the rule, despite that you are arguing. We cannot give any relief in contravention of the rule. This is the rule which debars you from participating in the further.
The rule clearly says that, my lord, a person is entitled for participating in future counseling. That is mentioned, my lord.
All right. Anything else?
Yeah. That.
All. Yes. Mark the presence heard on the question of admission. Petitioner is an aspirant seeking. Petitioner is an aspirant seeking. Where is the order passed in a petition and
Filed it through a memo
where?
on, there's a USR number 91623.
Where is the order?
also filed a brief synopsis.
When?
This is with memo number.
No, Mr. First, there's nobody has asked you to brief synopsis.
Yes, Lord.
We are asking where is the order passed in a petition under
That is
4.
along with the memo, Lordship. 916.
When have you?
WP 91623. WP USR.
No, Mr. This is 33350 of 23. In
Yes,
this,
Lordship.
an order was passed.
Yes, Lordship.
If you
Yes.
don't short memory.
No,
then
Lordship.
you-
I know that. I on
Give it-
15/9.
No. We give this facility even to advocates who are party in person.
I already
We should
filed
be
it,
more
Lordship.
liberal because you don't have a legally trained mind.
I've already filed it. It is filed on 15/9 with USR number, WP USR number 91623. It should be on record.
Not on record. 50. What is SR number?
SR number is WP USR 91623.
Write down, madam. Party in person submits that he has filed the copy of the order dated. What is the order dated?
Order is the order is dated 30 December 2022.
30th December 2022 passed in petition. What is CRP number?
CRLP 5048 of 2019.
5048 of
2019. 19.
2019. However, the same wide USR number. What is USR?
WPSR number is
WPSR number.
91623.
WPSR number. Please repeat.
WPSR USR number 91623.
91 so and so. However, same is not on record. Office is directed to trace the same and place it on record. List on 27/9.
Lordship, if I may, I have a copy if you would like.
We don't have. We don't have the copy. That's why we have.
I have a copy if you know, if you want.
27 September, Wednesday. Yes. Yes, Mr.
Yes.
Second case.
Yes, Lordship. Lordship, this matter, now lower court, a petition was filed by the other party. They filed actually a succession petition in which they filed an IA, and the IA they filed for claiming the petition.
When did you file this IA? As we have understood, your grievance is that you want a direction to the court.
Yes, Lordship.
To decide this IA.
Lordship, there was I filed under 340 CRPC. Yes, Lordship.
That's what is grievance,
Yes.
right?
Yes.
Correct?
Yes.
And when did you file this IA 340?
It was almost 2 years back, September 2021.
Date?
Because that's
You
one
tell
thing
us
I'm saying.
and what has happened?
What has happened is that
This is all you know.
I'm telling that, yes.
No. Mr. That has to be referred to by placing the order sheet of the proceedings on record that on this day CRPC application was filed and 2 years the court has not done anything.
Yes, Lordship. Only one thing is missing is that date on which September 2021 is I have the thing because the IA is at
But what has happened? And he had earlier filed a writ petition. What was the writ petition 18808 of 22?
Lordship, in that, what has happened is the other party, the petitioner, the respondent. I'm coming to that, Lordship. 18808, I'm explaining.
No, all we want to know is with reference to order sheet of the proceeding before the court that on this day you filed and thereafter the court has not done anything.
Not done anything. There is actually a deviation in the procedure itself. What I'm saying is that 340 CRPC petition, I filed a petition under 340 CRPC because they filed they have taken ex parte stay and then on the petition.
No, that means you don't want the suit to be decided. That's why you are doing all these tactics.
No, Lordship.
You don't want to see the litigation during.
No, Lordship. Let me please clarify. The issue is that when I filed under 340 CRPC and I filed evidence also, I submitted evidence showing that.
tell us the date of filing of 340 petition and the what has been done. Please, you will have to file an order sheet, Mr. Not like this. Order sheet and what is the order passed in WP number 18808.
18808, what am I,
Yes,
what my
please.
prayer was that it is not specific only to this case.
No, the prayer was say that 340 direction should be
Not
340.
one single, this concerning this single petition. A clutch of cases, what they have filed, they filed three cases against me with fake documents. They have started, I was pulled into all these matters by filing fake case against me by using fabricated documents. So my prayer in 18808 was that in all these three matters where they used fake documents against me and they started some kind of litigation against me, I wanted the Registrar General to investigate into the matter because wherever I am filing 340 petitions, they are not being taken on record, or if taken on record, they are not being adjudicated.
That's what we want to know. That really saying not taken on record is one thing and demonstrating it with reference to order sheet of the proceeding. Please obtain a certified copy. Please file it. That's what simple thing.
I'm coming to that. See,
There's no question of coming after you file order sheet.
I'm coming to that. See, what has happened is the only clarification is that
Do you understand
I
what query,
understand, Lordship.
what query we asked?
Your Lordship has asked me to provide with an order of the lower court.
Not order of the lower court, order sheet of the proceeding to show when have you filed a petition under section 340 that was filed in the year 2021. Thereafter, what has court done?
Yes, Lordship. It is at 32, page 32 to 47. Page 32 to 47. My petition I filed in 340 under 340 is at page 32 to 47.
2318. This was. What is 23318?
Lordship?
23318 is another petition you had filed.
That is a different thing, Lordship. That is under trial court. The trial court, they are not proceeding without any.
So what is the petition then? 23318.
23318. There is actually, I filed a complaint in the lower court.
You have to see, Mr. If you come to the court, you have to come with clean hands.
It is not connected to this matter, Lordship.
You file it.
It is not
You have
this.
to, we want to see whether it is connected or not.
No,
It's not that you will file and you will say that it's not connected.
Lordship, that is a majestic. One small submission, Lordship. That is a different matter, CC 1070, where I filed a petition, a complaint in the 14th Magistrate Court. This is a matter regarding a third senior civil judge matter. This is
So there should be no problem in annexing the copy of the petition to show that it is
23318.
Huh?
That I will do.
23318.
That I will
And order sheet of the proceeding. Party
Yes,
in
sir.
person. How much time? 2 weeks.
Lordship, it may be tagged with this because you already,
No,
Lordship
no.
has already passed a memo, a show cause notice.
No. This, when will you produce
1 week.
party in person? Party in person is directed to disclose the date on which the application under section 340 of the CRPC was filed by him before the trial. Next. You have filed, you want to withdraw?
Withdraw.
Learned counsel for the petitioner has filed a memo seeking leave of the court to withdraw the petition.
But in this matter, I request 1 week time.
Why?
It appears that the vacates the application.
Huh?
I don't have a copy of it.
My lords, we filed a case stay petition.
No, you tell us, Mr. Forget about vacate against the order which is passed. Huh?
Lord, I am not
No,
challenging.
1 minute. Against the order dated 26/8/2021, right? An appeal lies or not under IBC?
Lord, it is not a question of, I'm not challenging the order, my lord, your lordship may kindly look at the
Then-
prayer once again.
Prayer.
I'm challenging the very filing of the application because under section 60 of the Insolvency and Bankruptcy Code, in order for a section 95 application for personal insolvency to be filed, it is necessary that you file an application against the
No,
corporate.
what? So who has filed an application?
Milord, in this particular case, I have taken a particular, my company, Milord, have taken certain loans from the corporate, from
So you raised all objections in this thing, in that proceeding, that it can't be done and all that. The complete law tribunal will hear you and decide it. Why should we entertain this?
In the case of a personal insolvency under section 95, the moratorium starts on the date of filing of the application.
You have appeared before NCLT.
I have appeared before it.
If I may
We have no
make
intention of keeping this writ petition for next 50 years pending. No intention. Let it go there, Mr. This is all, Mr. Though there is an IBC code and this thing. In substance, you must realize that this all is a plea of dishonesty, right? Basically, you are a defaulter who has taken money, who doesn't want to repay the amount and rely on the technicality. This law is in my favor, that law is in my favor. Why? This is, even though entire law is you are in favor, taking into your conduct, we are not entitled to, we don't want to exercise this discretionary jurisdiction and you cannot compel us.
Your lordship, are absolutely right.
It may be IBC code, whatever.
Your lordship is absolutely right. However, let my friends submit, my lord, whether I am an NPA account and whether any recovery proceedings have been initiated against me or not. I am not an NPA account. That's the difficulty in this case.
What?
My lord, sir, there is an NCLAT order which squarely covers this issue. The decision is that a financial creditor can proceed against a personal guarantor
We don't
without.
want to go into this. He has entered appearance in the process. By taking into your conduct, we don't want to.
But I am not an NPA account, my lord, so I have not defaulted.
You are saying the first sentence is with a sense of pride. You said, I have taken money and I have not given it back. You said so. With a sense of pride said, I have taken money. This in good old times, right, Mister? When you were not even born, good old times, people would feel guilty.
I said
ask senior counsel, they would feel guilty that if they have not returned, if they have taken 10 rupees from you and they have not returned, he will return with a regret that, oh, sorry, I forgot this thing. Sorry, please pardon me. This is the amount I had taken from you. These were our, now defaulters come, say, law is in my favor. I have not paid it back because this is IBC is in my favor. It's all, this is of course off the record, right? As we are telling the law, IBC binds us off the record, you understand the substance.
Absolutely, madam. I only have one submission, madam. Your lordship may kindly.
You are challenging that the application, this thing should itself be quashed in the writ petition,
Yes,
right?
Lord. The reason for it, Lord, is that the law is very clear on. Your lordship may kindly, like,
We don't want to.
62 of the Act. It says that only when you have any, there is a.
No, you take all the plea. It's open for you to take all the plea. Either we say that or you want, we will pass an order, whatever.
May I request this, Milord? Your lordship may say that the moratorium shall not come into operation.
We will not say anything. We will not say. You go there, do whatever. If law declares it is the, why we do, you don't want our seat, this thing. No, nothing.
Milord, my difficulty would be that there is no debt as of today. Because there is no debt as of today, they cannot initiate a Section 95 application against me. If there is a debt, they can initiate a Section 95 application against me.
Fine. All right.
That is what?
We have heard you, yes. Anything else?
Milord, your lordship may.
See, Mister, I'll tell you one, I'll tell you this thing, my experience, like there was under the Madhya Pradesh Act, this local bodies used to levy tax, right? So, and it provided levy of tax on agricultural market committees used to levy tax under the Agricultural Market Committees Act, right? So our this thing clients, partnership firms, they used to change constitution of the firm within 3 years every time, and to seek they used to evade tax. So, and there was a judgment of Supreme Court in my favor, 1995 Supreme Court, saying that if like that it can't be recovered from me because I am a newly constituted firm. And I filed the petition made in the petition drafted that 95, so didn't say in the petition, but I brought that book and agricultural this thing. So judge said that you have brought that 95 Supreme without anything. I stood up and said, you have brought that 95 Supreme Court. So he said, yes, sir. I so said this squarely covered, sir, by 95. This demand cannot be made against me. So he said that this jurisdiction is discretionary in nature, and I don't want to exercise in the facts of the case. What you have to say? When you believe me, it's like I'm telling you that we told the judge that I have nothing to say. He said dismissed. Extraordinary discretionary jurisdiction, even though law is in his favor, because this conduct of repeatedly changing the constitution of the partnership firm and avoiding tax, though it was now, as we can say, that Azadi Bachao Andolan's case, Supreme Court may say that it's a tax planning, which is permissible. But at that time, 95, I am talking about 95, he thought that this is a dishonest conduct. So, whatever you argue, what entire law in your favor, we are simply saying it may be in your favor, but we will not.
Your lordship may only protect my interest for limited
Nothing,
time.
no,
I'll take up all content and so.
No interest. Yes, who are you? You are a guarantor, right?
Yes, no, I'm a personal guarantor.
The respondent heard on the question of with consent of the party, the matter is not filed. In this writ petition, the petitioner, who is a guarantor to a transaction, has assailed the validity of the action of Invest Corp.
May I please? I am for the writ petitioner, not the state preferred, the first department preferred the writ petition, not. Now the short point, not the, I make the two short points, not one page of the synopsis, no? The HRC acted without not the jurisdiction.
That we
and conduct plus suppressing the material facts and the writ petition order. They obtain the misled the even HRC also.
Similar order.
So 1940.
Array that. Sarita madam. Leave. So we, anybody remembers, we have passed an order holding that Human Rights Commission has no jurisdiction to, and Supreme Court judgment with so many judgments with sitting with Justice Vinod Kumar. Supreme Court judgment.
I am appearing 2014. No?
You are appearing for complainant.
One and
Complainant.
yes.
Then how
Approach to the Human Rights Commission.
Approach appropriate forum. Human Rights Commission cannot do anything.
But the only difficulty was he was not allowed to cultivate his own land, which is
that's all right. Not allowed to cultivate. That means you will not go. You will not go to.
I can understand what should contention.
This all
Difficulty of a citizen who is a farmer, except this land, there is no other land for him, and he is a valid.
Our difficulty is law. If law permits, we can do it. He may be a crook of the first order, but he is entitled to protection of law. What can be done?
But whatever the synopsis.
No, there's no question of synopsis, right? Nobody. No question of synopsis.
I may be permitted to come for some going through this. What is the
No, Mr. The only this thing is that you have made a complaint.
Yes.
To the Telangana Human Rights Commission.
Yes.
Right?
An interim order was.
And your this thing was, your case is that I am assignees and pattedars of the land, forest officers are trying to interfere with my possession.
Yes.
Thereupon your complaint has been admitted by Telangana State Human Rights Commission and order has been passed on 28/11/22.
Yes.
You know it, right?
Yes.
It's not my case, right?
No,
so that order is under, you are just trying to.
Not they are challenged.
Time.
No, I am only submitting.
The law remains the same. It won't be, see, Mr. You want an adjournment, but this Manikamya's judgment will not change. Article 141.
I'll try my clients to satisfy the Honorable Court with regard.
There's no question. You argue
because now the point is, they are claiming the forest land of thousands of acres, wherein there is no such forest land.
Please see this order, Mr. Our predicament is that these are all covered matters. So we can't take a different view. Please see. Your remedy is to travel northwards. Please.
Part
of the writ bundle.
Please see the order.
It is also part of the writ bundle. Page number 115.
Please see the order. Please see the order, then argue. We are ready to hear you, provided you see the order. No, not the facts of the case. Turn over the page.
Yes.
Section 12. And
Yes,
Supreme Court decisions.
Section 12, section 2D also.
Give that. You have seen, right? 1 minute.
Section
Let him. 12 and Supreme Court decision.
Let me an opportunity to submit the other aspects of the case. Only a final opportunity, so that if I am able to satisfy the Honorable Court,
there is a stay operating in your favor.
Lord, this judgment is also accompanied in the writ bundle, page number 115. My humble submission.
The last time also you, Mr. Rao, you sought a journal.
I know. I filed because the papers was
no, 8/8/2023 you were granted time.
No, not time. For filing the additional count.
Then again, so it's not that seeking adjournment is your fundamental right.
I am not on that.
That you are saying that grant me time to. So what purpose the case is listed today?
I can understand.
What purpose the case is listed? This is, Mr. the way you cooperate with the bench, right? That seeking adjournment repeatedly.
I'll come up with all the relevant, as my learned friend submitted the judgments, I may be permitted to take a chance.
He has not submitted any judgment. This is our copy.
Yes.
He has not submitted any judgment. We are telling you that one has to be, please remember, Mr. Rao, one thing, this case will be adjourned, no problem, right? But we carry an impression that you are not fair to the court. That's let this not happen. You are an officer of the court. You know the decision of the Supreme Court. You know that the result of the case is inevitable. Still, the tendency is to buy time. We don't have any problem, right? There is a stay. Unfortunate. That's all we can say. But we will remember you when you appear in other cases. We will remember that here is a counsel who is officer of the court who is not fair to the court.
Right, it's not like.
Fine.
I see.
We are admitting petition is admitted for hearing, interim order is made absolute. It's not that we get anything by deciding this. Not that we are getting an increment of some 2 lakh rupees by deciding this. No hurry. This shows your approach. That how now next case you come and you say that we will tell you the law.
With great respect, madam, only one submission. Just now the court observed, madam, when they come with the true facts, madam, I can understand. Madam, it's the case entirely has been with false facts, madam, I can prove. That's what
the order is not
maybe law may be on their side, but on factual position, madam, they are totally wrong. What that much I can.
No, this under Article 226 we can adjudicate the facts and ignore the order passed by Human Rights Commission, right? In contravention of judgment of Supreme Court, in contravention of Section 12.
Yes, but forgetting about whether the jurisdiction is there or not.
My fault.
No, they stay operating.
I lost I back. The officer senior counsel, Srinivasan appealing for the respondent number 5. Senior has been hospitalized. My notes.
But there is a report filed by the Pollution Control Board stating that there was a directions was issued to the 5th respondent.
No, the counsel is in hospital, right?
Understood.
Then what do you want? When do you want?
3 weeks, my notes. He has been complaining the dark bags.
Huh?
He's been diagnosed with dark bags. He thinks a time and
With regard to the time is concerned, not outside. With regard to there is a.
You know any remedy for gallbladder stones? Go to the council, tell him and get him discharged from the hospital. We will hear Sunday also.
No, I'm not saying that.
We will hear you on Sunday also.
No, I'm not saying. Only by request is the Pollution Control Board may take action as per their own notice. I'm not saying against.
See his predicament. He doesn't understand anything. This person who is saying.
I'll leave it to that.
Then he will say that his junior will say that even though I was in hospital, his senior will say that you are not good enough even to seek an adjournment. After to be optimistic, Mister. We believe that he will be all right after 2 weeks. Who you are appearing for?
fine. Respondent.
Mr. What's your name?
Vicky.
What happened to your voice?
It has been like this.
Like this only. Okay. We thought that this cold drink you had yesterday. Learned counsel for Mr. So and so learned counsel for learned counsel who appears for respond number 5 submits that the arguing counsel, who is the name? What is his name? Arguing. He is hospitalized as in unwell. In view of aforesaid submission, hearing is deferred. List after 2 weeks. Yes. Counter is to be filed, Mr.
Yes, my counter is filed.
Filed?
Filed. They agreed to my submissions. But I also filed an IA.
What IA?
For amendment of the amendment. Because instead of general administration, it was typed as a director of school education.
All right.
They admit in the counter that there were a procedural. The challenge is to the GO 21.
All right, so we'll allow the amendment.
Yes,
this will have to be heard on so and so, heard on IA number 2 of 23 in all the right, whatever is IA, taking into account the nature of proposed amendment and for the reasons stated therein, same is allowed. Let amendment be incorporated in the writ petition within 1 week. One petition pleadings are complete.
Yes,
petition is admitted for hearing. 21.
Interlocutory application, I'm seeking for a stay, my lord.
Which stay?
In this.
So let IA 2 of 2023 be listed for consideration on
1 of 2023.
Lord, the PIL filed for issue direction to concerned authorities for establishment of the mental health destitutes for seeking the welfare of the destitutes and
counter
thousands of
File counter millets.
counter filed Millard and reply
All
also
details are given Millard in the counter.
Huh?
All the details Millard about what are
Counter
the.
has been filed.
Yes, Millard, filed.
Every respondent. Yes.
The fourth respondent has filed the counter Millard, on behalf of the state.
Others don't want to file.
filed Millard counter. All departments are filed counter.
Everybody is saying respond number 4.
For 6 respondent, all party. 6 respondent. I'm for a 6 respondent.
You don't want to fight. All right. What about others don't want to fight?
Lord, I represent response 1 to 4, 1 to 5. 1 to 5, Lord, I represent response 1 to 5.
1 to 5.
Yes.
They have filed.
Yes.
6 has adopted, 7 is member secretary. All right, fine. So what is Mr. and rate of mandamus not implementing? Where is your counter? What have you said?
Well, the petitioner says that not the mandate of this Mental Health Act was not being followed. But we have mentioned in detail very clearly that what are the various steps taken.
Where is that? Counter.
Yes, counter. Page 12 on page 4 onwards. It's in fact the petitioner Millard earlier filed. Millard, petitioner is an NGO Millard.
Its job is to file public interest litigation. It is engaged in the business of filing public interest litigation.
One aspect I'll submit. He was running a rehabilitation center in the hospital at Sangareddy Millard. But the hospital was sought to be demolished.
1 minute. What have you are not telling us, Mr. What paragraph, what is, have you said?
But para 12 onwards, Millard. But for para 11, my lords, may kindly see, Millard.
1 minute.
Para 15, may kindly see.
Yes, Mr.
Millard, Millard, the PIL filed very seriously, Millard.
We did not say.
I'm petitioner. Petitioner is establishment one social organization in Sangareddy.
No, forget
Instead-
about it. What is your grievance? How
now,
Mental Health Act are not being complied
yes,
with? We
Millard,
want
Mental
to.
Health Act.
And your office, your role in a public interest litigation is not adversarial litigation,
The
right?
the act is not implementing by the authority.
Just like saying this is enough, right?
No, Millard.
All right.
I am submitting and reply also filed. Reply also filed, Millard. What happened, Millard? The
Mental
petitioner-
Health Act.
Let's may I submit one aspect. But he asked for allotment of 5 acres of land, Millard, to run a rehabilitation center.
And it was not
That
given,
was not
so he has
allotted.
filed PIL.
But that was not allotted, Millard.
No.
He has filed PIL.
Later again, Millard, he now says he needs 10 acres of land. Millard, page 16.
No, Millard, the matter is.
Page 16, para 4, may kindly be sent of the affidavit. Millard. Page 16, Millard, para 4 of the petitioner's writ affidavit, Millard. But he was running a rehab.
1 minute. See, Mr. We have to now find out. This is the level of assistance. He is saying that I have filed it seriously.
Yes.
So we have to read and pass an order.
Yes.
He has done his job. He has lost locus in any case. Sheila Barse operates against him. We will appoint an amicus curiae to help ourselves.
Pilots.
Ah.
Page 16,
Yes.
page 16,
Page-
Millard,
16.
para 4.
Para.
Internal page 9 of the affidavit. Millard.
9.
Millard, of the PIL filed by him, Millard. Para 4.
No, counter filed by, counter of?
Not counter, Millard.
Read petition. Facts. Facts in brief. What is it?
But two pages later, Millard, after facts in brief. There is one paragraph.
Para 4.
Yes.
Notice.
But it is further, it starts with, it is further submitted. May I read it?
No, there may be a cause of the motivation, but still, as a court, we can monitor implementation. Forget him. But we can, this issue has been brought before us.
Yes,
We can see mental health act.
Section 18 of the Act, Millard.
Don't, Mr. Mental Health Act, madam.
Is it, madam? This one.
Why to take his book? So various provisions, Mr. Your, this thing, we don't think it's, satisfy all the, this thing.
Section 18, Milord. Section 18 prescribes what are the various services the state has to extend to the persons in need of mental health care, Milord. All those aspects have been answered in the counter affidavit filed by us, Milord. My lords, if my lords go to pay para 19.
How many, this thing, hospitals in the state
My
you
lords,
provide mental health services?
Milord, that is para 21, Milord, 25, Milord, para 25 we have mentioned.
25.
Para 17, I'm sorry, para 17. But in 27, medical colleges are there in every, each one in each district, my lord. In every medical college, there is a hospital.
Where have you said?
Para 17, Milord. It is submitted that
Mental health services
are being provided by 27 medical colleges in various districts with the established psychiatric department providing outpatient and inpatient services. The government hospital for mental care is providing services for mentally ill persons for the past 70 years relentlessly, treating them till recovery, till handing over the patients to their family members. The mental hospital is protecting the
Who are
rights
the persons who deal with mental health care in these hospitals?
of the
Medical colleges.
psychiatry department. There is a dedicated psychiatry department, my lord, in every district, my lord, in every hospital. But tablet forms also are given, my lord, in the counter affidavit. If my lords go to para 19, my lord, below that we have given, my lord.
Para
19, my lord, beneath that. Patients getting treated in various medical colleges across the state. But month-wise we have given, my lord. Department of Psychiatry, but this is the
government is
department which is extending the service. But it is not a case, my lord, where there is the disproportionality between the patients and treatment. Not every person who is in need of medical care, mental health care, but is being treated positively by the government.
No, that's good. But still, scope of improvement is everywhere. You cannot say.
But that is an ongoing process, which is.
Also, what are the measures which you are required to take?
But para 21, that is, my lord, section 18 says about the various measures to be taken. And my lord, rules, my lord, rule 3, my lord, in the rules prescribed halfway homes, my lord, for those who have already been treated but still need some care.
So where is about this right to community living of these people if it is not possible for them to stay with their family? Have you identified the people?
Yes,
who cannot stay with their family, but
that is at para 21 we have answered it. There are two types of halfway. They are called halfway homes, my lord, which is defined in rule 2C, my lord. Rule 2C defines halfway home, my lord. Those who have already been treated and cured but still need some kind of care and are not integrated with the family, my lord. But for that,
so all, I mean, whether 25 bedded this thing?
Para 21 in the counter we have mentioned. But 2 NGOs were designated for the purpose of housing such type of.
But 25 bedded, how many people are living?
That is mentioned, my lord.
36. 20 hospital is 25 bedded, 36 people as per your own showing.
But
225 bedded. Acha, 2, that
yes,
means
2.
50.
Yes, but below that there is a table, my lord, where the details of the halfway homes are given, my lord. But home for disabled, Ansilalpet, Secunderabad, my lord, gender for whom facility exclusively meant for males. This is exclusive for male, not 29 inmates are there. But Kasturba Gandhi National Memorial Trust is for females, my lord, that is 7 persons are there. But these people have already been cured from the disease, my lord, but they need some post treatment care. My lords, next page, my lords, may kindly sir the counter, my lord. Mental health care programs, what types of care programs are being taken? District mental health program performance in various districts, my lord. District wise we have given. That Hanamkota 876.
So what else is required to be done? You tell us.
But few more shelter homes, halfway homes will have to be established, but depending upon the inflow of the persons.
How many distinct total persons you have identified in this state who are in need of this?
36 blood, only 36.
Only 36?
Only 36 blood, that is given at page below para 21. But the petitioner points out.
No, total number. State only 36.
Only 36.
No patients. Oh, so nice.
Those needing,
Good
those
to
who are,
know.
my lord, those who need halfway homes are blood, they already have.
Not halfway home. We are generally asking you how many patients have you identified? Probably it's in 5 figures, not 36. Some 1,000 you have mentioned somewhere.
That is at page. That is at para 15, my lord.
Para?
Para 15, next page.
This.
Next page.
31,000, yes.
But,
hospital?
Out of 31,000.
Which hospital?
Out of 31,841 number of patients admitted in hospital from 2014 to 2023, 29,994 number of patients were discharged after recovery and 27 patients died due to said period. Even 27 patients died due to or not due to lack of medical care, but because of their own health, cardiac arrest, such kind of ailments, they died. Hence the allegation.
No, so then what are the provisions which are required to be made by you?
Well, provision is not in every district. There must be a mental health healthcare facility.
You said every district it's there.
It is there. Provision is that law says that there must be mental health care facility at every district. That is being done. That is there. That is already there. But my submission is petitioner has not made proper verification. He has filed the PIL. Petitioner has not made proper study and he has filed the PIL. But absolute mental health care is being extended to all the parts of the state. Well, but the sheet next to 15 para 15, my lords may kindly see we have given a tab.
So, Mr. What are your suggestions? Prepare suggestions in writing.
Yes, my lord.
No. Instead of arguing for 1 hour, you are an officer of the court, right?
Yes.
You have filed this PIL to assist the court. They are not fighting it. They are saying that we have complied. You give a list and your suggestion, what else is required to be done?
Yes, my lord. I kindly ask.
You prepare a synopsis.
I submitting. Yes,
They are not submitting. We are not stenographers to write whatever you are writing. Give a note. What is required to be done by the government, right?
Already I filed reply.
Where is that? Do you ask him to give a separate note? Where
Please
improvement?
give a complete gist of what exactly you need. And what exactly.
What in your suggestions we will implement it. It's not, there's nothing to argue for 1 hour by reading one paragraph here, one paragraph there, then page 144, nothing. You give, they are ready to comply.
Yes,
so they are not contesting your claim. You give your suggestions in writing.
Okay.
Learn it, mark the presence. In this petition which has been filed as public interest litigation, the petitioner inter alia seeks a writ of the grievance of the petitioner, which is a non-governmental organization, is about non-implementation of provisions of Mental Health Care Act 2017, as well as the regulations framed thereunder in the state of Telangana.
But in this matter, respondent number 225 have filed their counter merit, respondent GHMC. But we have, last occasion merit, there was a direction to file a status report.
Yes.
We have filed a counter merit stating the facts that we have addressed a letter to the JNTU merit to conduct structural stability. The inspection for structural stability, that report is awaiting merit. Page number 16 is the letter addressed to JNTU.
Who is appearing for GSC?
JNTU is not a party to this writ petition. JNTU is not a party to this writ petition. Yes, ma'am.
The Subot has taken up by.
Subot have taken up PIL.
Who is not a party?
JNTU is not a party.
JNK?
Jawaharlal Nehru Technological University. A competent authority to pass orders on the
We
structure.
heard JNK, so we thought Jammu and Kashmir. What are you talking about?
No, I apologize. That's an institution.
Therefore, we should refrain ourselves from using
I
the
apologize.
abbreviations in court proceeding.
And page number 17, your lordship will.
So you have written and then you will sleep, right?
No, my lord. We have taken steps also, my lord. The final notice is also issued under section 456 to all the inmates. At
You
page
are
number
saying-
17 to 31.
Mister, you are saying that we have written a letter, report is awaited. Then that means what does it suggest? That you will take action only when report is received. Then you are trying to tell us he is not a party. So JNK is not a party. Therefore, you are trying that JNK will never respond. This is the impression given, right?
One submission, my lord. Page number
Please
15.
understand, Mister. What the impact of your submission, which that we have done our job. We have written a letter. God knows when they will respond. By that time, it will be fall down itself, and then we will say it has fallen down.
Page 15.
Status report. You will
Page
file
number
that it
15
has
for a
fallen.
moment, my lord. Page number 15 for a moment, my lord. That is the engineering wing of GHMC also conducted inspection.
Wrote this thing. Give this also. But to give complete file. Don't keep counter there. No. So you have a written letter to what? So what?
For conducting inspection and to give a structural stability report.
What is your stand, Mister?
At page 15, engineering wing has already identified the structure, my lord. At page 15 is the engineering wings report, my lord, of GHMC. Later, they have addressed a letter to JNTU to give a structural stability report. Basing on that report, my lord,
Then what is your stand? So that's all. That's the end of it.
my lord, we have taken enough.
So thereafter, you have written letter. Then what will you do?
But we have also taken enough care in
Be in deep slumber and wait till it falls. This
No,
is
my
the submission.
No, there are
You have to proceed further. You 3 times you have told that we have written letter to so and so.
the further
Who is
action.
not a
Page
party
number
to
17 is the further action taken by GHMC. My lordship may kindly take page 17. We have addressed all the final notices to the inmates, and we have already taken care of vacating them from the premises.
3 times he is telling I have written letter, and he is not party.
Please state what further steps you have taken. That's what we are asking.
Page number 17, my lord. Final notices were issued to the inmates to vacate the premises.
You are.
We have already taken care of evicting them from the premises. My lordship will find page 17 to 31. 90% of them have vacated the premises. 10 people are disputing. They want a structural stability report from JNTU. They are disputing.
So have you filed a caveat in respect of those people who are not or waiting? You are waiting, said they go and obtain an injunction.
No,
Then,
after JNTU conducting an inspection, well, it will take further action.
then you this thing report compliance.
Your lordship may kindly have it next week, my lord. Or in 2 weeks, my lord, I'll file a status report, my lord, on the action taken. Finally, your lordship may record.
Learned counsel for the PT. Who are you?
Respondent 2 to 5.
Respondents 2 to 5.
GHMC.
Greater Hyderabad Municipal Corporation submits that on the basis of the complaint made
on item 23, my lord. 24, I'm not concerned.
1 minute, let before my learned friend starts. Item 24, your lordships, when the hearing commenced, it was noted that we have challenged the assignments made to 7 to 13 respondents, but the GOs challenge were not made. And therefore, an amendment was sought to be made, and the time was granted to file an amendment application. We have filed the amendment application, yesterday it is returned. May I seek for about 10 days leave, 10 days adjournments. The reason is, some of the GOs, they wanted us to file, and the government has filed only some GOs are allotted.
No, we did not direct you to amend it. It's none of our job.
I never said, your lordship directed, but we wanted to file amendment, challenge the GOs.
No, see, Mr. Last date of hearing, you prayed for adjournment 14/9.
Yes.
We have adjourned it to next week.
Yes, I filed the amendment applications, but they were returned. Yesterday it was returned, and we had to represent it, and the objections were we have to file some more GOs, for allotment. That's the only reason I asked for adjournment.
But this is pending since how many?
I do apologize,
17 years.
I do apologize, your lordship.
I don't know what is your prayers and what can you challenge. It will not, this thing, Mr. After 17 years, if you are challenging some GOs, you know what is.
But the GOs were only for
Mr. We only request you, Mr. Please argue. I mean, this has been listed. Once you have been accommodated on 14/9, there is absolutely no justification, right?
At least, lordship, I have it on Monday. I'll represent the amendment application.
Why Monday?
It is written. It is returned yesterday. That's the difficulty.
So when you have been sitting in the court for almost a week, we have seen you here. And this thing, all of a sudden, this thing that amendment is to be.
Yesterday,
why it is we should not challenge it and dismiss it on the ground that it is an afterthought, and this thing, all this. You have been sitting here for weeks together.
Because I requested my
colleague counsel, Mr. You have to be fair to the court, right?
I am fair, I requested my colleagues to ensure that it is placed on record. That was the reason why I was waiting.
You know, he is 23. He is appearing at 23. You are making a prayer for 24.
24.
No, but we are 23 has been called.
23 and 24 since minutes. 23 and 24 both were called. That's the reason why minutes.
Mr. Tell us, Mr. If you would have been a judge on this side, what you would have, supposing we would have been counsels.
I'm sorry.
What would you would have thought that would you not have that you have been sitting here on this very chair? I remember patiently for weeks together. And last date of hearing, please see the order sheet. On your request, the case was adjourned next week.
Yes, madam.
And again, when the case is, it is about to be taken up, again you adjournment. Supposing if we refuse to grant, let you challenge it in SLP. That will be an additional ground. We don't know what order you may be succeed also in this petition, but we are not granting adjournment. Sorry, Mr. Senior Counsel, we are very sorry. We don't, because see, if we grant adjournment in 2011, all youngsters are sitting here watching. They will feel that the seniors get away whenever they want, and the court is strict for us only that they said no.
Everyone knows your lordships are refusing adjournments.
So therefore, we want to please, we will record your submission that you are now saying that I should be granted opportunity to amend. We will say that after 13 years, and we will not permit this amendment. Let it be. You address us on merits. Whatever happens, you may succeed also. Who knows? We don't know the subject matter of your petition as of now. Please cooperate and argue. Let him argue.
Please, your lordships. I am appearing in item 23.
This all, see, all cases are listed with saying that identical, and when it comes to then different. Same thing we are doing.
Now, these
every case passing different order.
Two reflections of mine, my lords, were pleased to allow it.
But this is different. We will have to again write facts and everything.
16.2 is the order. The challenge which is at page 143. But my first submission was.
Give us this thing, Mr. Synopsis or something. I mean, who will make notes now? It's altogether a different matter. You said in the beginning itself.
No, your
What is we don't
second
know.
matters were allowed by my lords, Milord. The writ appeal of the state was dismissed. Another writ petition of mine was allowed.
We do not have the benefit of such an amazing memory.
No,
You have, because see, we deal with so many cases.
No, one thing I
every day.
Milord, I have noticed my lord's immaculate memory.
We don't have. Therefore, we don't know what is this appeal. This is writ petition or appeal? Writ petition. What is the prayer? What is the synopsis? What is the amendment in your petition?
No, the prayer, my lord, your lordship said the last time not to dispose that, not to grant patta was not there. Your lordship molded the prayer in the other writ petition. That is the reason I made this prayer. So that
But it's surprising that every case you are saying different and we are made to write different orders.
No, same thing.
What?
Same as my lord, the Shamrao and Nakuludu.
Where is Shamrao Nakuludu?
Yes, madam.
Where is the order, madam? Do you have at least so
These are
that
the
we can
submissions. These are the submissions on behalf of the resident.
submission order?
The
WP number if you can give.
My lord, yes, my lord. The date of dismissal is on 13/9/2023, my lord. Writ appeal number 737 of 2018.
Write down, madam. Get a printout and other case.
Yes. The
No,
other-
not writ appeal, his
Not
petitions.
Writ petition number 25672 of 2007.
That is Shamrao.
Dated 14/9/2023.
Write down. Give a printout, madam. We don't remember what is it.
Paper is there.
And the other one is writ appeal 937 of 18. And only to recapitulate your lordship's kind memory, my lord, please see page 143 of the paper book.
Madam, amendment, what do you want to say?
My lord, with regard to the amendment, my lord, my submission is in paragraph 5, what they have stated that they are similarly situated, they are not similarly situated.
No, amendment.
Yes, my lord, amendment also, I am not accepting the IA's amendment, my lord, with regard to the second part. Second
What
part.
is your stand on amendment? What,
Yes,
like
madam.
you cannot argue on merits of the amendment? What you have?
My lord, amendment with regard to granting of the patta certificate. Your lordships would get it at page 10 of the IA.
No, but in another case we have granted, molded the relief. So yes, by way of abundant caution, yes.
16/2/2006, my lord, the joint collector order has been set aside by the learned single judge.
See, we don't get anything, madam. We don't have that benefit of that memory photographic that whatever you say, that order set aside means the entire order is before us. It's
My lord,
not
in
so.
brief, I have just made notes, ma'am.
Or may I make a synopsis and give a lot of the whole thing?
That you should have done. That is the least you could have done. These people who stand around you don't work, that means.
But we'll do that. Will kindly accommodate us for some time. By Monday,
No.
we'll do that.
We have still 40 minutes.
By Monday, we'll.
No.
Blood in a nutshell, I can blood it.
But 1 minute, please give us 5 minutes at least. We have to write an order. You are on to submissions, but we cannot have the privilege of that directing.
That's
This is
always the court's prerogative. It's always the court's prerogative.
No, but you are here to assess the court.
That's it.
Your final hearing, and you will start telling the facts that he was born in that village in Medchal, Malkajgiri district. We have to write facts also, no? We are reading it. Our order, we have taken oath. You have the prerogative to challenge it before Supreme Court if it goes against you. But we have to do ourselves.
Same matters.
What to do? This is the least you could have done.
Your Lordship,
Least,
as a
Mr.
glance at
That means the bar still doesn't know me. Like, I mean, no lawyer would appear normally without synopsis in like facts at least. There's nothing
we
we
have
could have
given
helped us.
earlier
We could have finished off.
Earlier occasion, I think I've given it.
Fine, all right. Husband Reddy joined.
I did give, my lord. I have a copy, my lord, I can still give.
Discharge. Discharge. 13/10/52 assigned in favor of labor not. Arey, madam, where is that printout of the judgments? No, no, facts we have written. This is, all facts are stated. Order in WA. Not getting. These all facts are there. WA 737. 737 of 2018 dated 13 September. Is looking thoroughly inefficient. See, they should be in the fingertips. Two people should look at that. We also say critical. What to do? This one. He was also part of that. He has been rejected. Your name is not there in the notification
It
dated
is
5
not, kindly see the additional documents now filed.
5/10/79.
Even prior to that in 1970.
No, 5/10/1970.
My name doesn't figure there. But the fact remains is there was another proceeding drawn prior to 79, which is at page 211 of this yellow book.
When have you filed this yellow book?
Along with an application.
Then they are entitled to be given an opportunity.
Let them look into it, not at all.
This yellow book, they have 5 documents, madam. Gone through ready, no? You don't want to, like, fine.
Please see page 211.
Yeah, what is the previous proceeding?
211.
What is it? Tell us the background.
I'll just tell you, Lordship. No, I'll just tell you, Lordship. But your Lordship gives me 5 minutes, I'll indicate the whole thing. The present petitioner was also a petitioner in the earlier round of litigation, wherein Justice V.V.S. Rao gave certain directions. Those directions have not been complied with the authority. So therefore, the present writ petitions have been filed. I contended before the Honorable Court, the order is sheer without application of mine. Therefore, the same is liable to be set aside. So far as Nakulutu and the other person, that is Shamroy, is concerned, their names figured in the notification of 79. So far as the present petitioner is concerned, his name figures in the notification of 1970, 9 years prior to that. Initially,
what is this? 1910/70.
29/10/70 is drawn by the government proceedings of the cooperative sub-registrar. If your Lordship sees in the press notification cited as item number 1, particulars of unauthorized allotment made previously were called for along with military discharge certificate. But so far as the petitioner is concerned, he was a participant in the Second World War, and he got a pension, which is at page 27 on that count. On receipt of the particulars of 194 individuals, the ad hoc committee constituted of the collector Hyderabad district, in its meeting held, resolved to examine each case of allotment through the selection committee comprising of the registrar cooperative society, secretary district, soldiers, sailors, and airmen's port Hyderabad, select individuals to fulfill the requirement. As a result of the scrutiny made by the deputy registrar, so ex-servicemen were found eligible for admission. Then kindly see the names drawn. The name drawn is at page 213. The name of the individual is B.K. Chakravarti. Initially, this was given to him in these two survey numbers 107 and 1008. Chakravarti never wanted this. He showed his disinclination. So therefore, he was given at Paurampet 1007 was given to Sham Rao, which writ petition was allowed by the Honorable Court. 1008 is given to the present petitioner.
Where it is given?
Survey number 1008.
There, where is the order of allotment in your favor?
That the lordship would get at page number 15. This is Jawahar Nagar land colonization, Balkara Metchal Taluk. This is to certify that ex-Havaldar Major Kesav Reddy, son of so-and-so, World War II, has been allotted 5 acres in survey number 1008 in Tumkunta sector, Metchal Taluk from our society. As per the society allotment, he is in possession of the same. Kindly
You have made a society a party?
Society is a party to this writ petition. And kindly see.
He is appearing for society. You are appearing.
I'm not served with any papers. I'm known to me now. I don't know.
Please at least see the documents, Mr. Like after 13 years, you are a party. How can you say that I don't know anything?
But it's not, notice has not been served to us. We do not have
Not
the
served?
copies.
Find out when it was served.
I'll
We
take it.
will tell you when it was served.
I'll take.
And kindly see page 17.
No, but Mr. The distinction being that this certificate issued by cooperative society will not bind the officers of the government.
Please
There, the officers of the government were involved. This is the
Please see
distinction.
page 17, Taluka Operative Officer. Page 17, Special Officer to Society. This is to certify that Kesav Reddy, member of so-and-so, for ex-serviceman, is in possession of 1008 5-acre society, so-and-so. The issues as per the records of the society. This is from the Taluka Office Cooperative.
He is an officer of this society.
Yes.
Again, yes. Now, what else?
Kindly see page 18 also. To certify that Kesav Reddy. That he has been in continuous possession for more than 40 years. And he filed a civil suit even against the government when they tried to interfere. The suit was decreed. Interlocutory application went up to the Honorable Supreme Court. Supreme Court said that my client is in possession of the property.
What happened to the decree?
Suit decree. Attained finality, yes.
Where is
There
that?
is no appeal filed.
Where judgment decree?
Yes.
Which page? He filed a suit for permanent injunction.
Yes. 118 page of the yellow book.
118.
Kindly see 117 also. That is the order of the Honorable Supreme Court which went in the interlocutory application. The Honorable Supreme Court disinclined to interfere with the injunction granted. We do not find any ground to interfere with the impugned order of the CRP of the High Court, which confirmed the injunction. The trial court was directed to dispose of the suit. The suit came to be decreed, 118. Samyukta is his wife, Sridhar Reddy is his son. The suit was decreed. All these people were cross-examined thoroughly. As many as 60 exhibits were filed and marked. There are 33 suit is decreed. 159.
No appeal filed?
No appeal. And thereafter they issued a notice also
I'll
under
make
the
my
assignment law.
I will make my submissions after.
Of course. No, but you did not even, you must have obtained instructions with regard to these documents, no? Yes. Then, so you were found to be in possession, that's
I'm
all.
in possession. They issued a notice to me under the Land Encroachment of Act of 1905. I gave a suitable reply. They choose not to take any further action. They drop the proceeding.
What
40
is-
years plus I am in position. My entitlement is legal and lawful. I am similarly placed because Chakravarti 107007 was given to Sham Rao, 1008 is given to Kesav Reddy. Now this yellow book contains every document, payment of taxes, possession, agricultural transformer was established there. Chakravarti was allotted at Porampet, that your lordship would get at page 7. And that he never disputed. Page 7, Chakravarti was given in Porampet. He disinclined to take it here. That is how we got it. I and Shamrao got it. Please see page 7 of this paper book. He was given at Porampet. That is the reason Chakravarti name is shown.
This is given by the society, please take 17. Illegal possession. It should be government authority. It will say right to be. Should not be studied of the place.
And the other two were not even, whose repetitions were allowed, did not participate in Second World War. My client participated in the Second World War. And the entire land was only meant for ex-servicemen.
Why it has been rejected? Where is that order?
Rejected, that impugned order is at page 143 of the original papers. 143, commencing at 144.
Yes.
In the common order, my lords have got it.
143.
144.
Yes.
In the common order dated 15/3/2004, the Honorable High Court has given the following directions. Where the ex-servicemen have been actually in possession of the land and have brought the land under cultivation within a period of 3 years from the date of allotment by the society, the MRO shall consider the case and regularize the possession by issuing three-form patta in favor of ex-servicemen or his legal heir wherever necessary. This direction applies to us. Now kindly consider how the authority considered it at page 147.
Yes.
In the instant case, Kesav Reddy has applied to the MRO for assignment, accordingly inquired the eligibility.
So you are Kesav Reddy, right? Like your
Yes, yes.
petitioner's husband is Kesav Reddy.
The name of the applicant is not found in the list. The applicant is not in possession. The applicant is not a JLSC allotee. The applicant did not bring the land in cultivation. He is not an ex-serviceman. This is how they answer it. A person who participated in the Second World War, that certificate is at page number 27 of the yellow book. Page 27. This is given by the Department of Sainik Welfare.
This order is that okay. To the units.
The authority says he is not an ex-serviceman. Kindly.
This order dated 25/3/2004 has attained finality, no?
Yes. The suit decree.
No, 25/3 passed by learned single judge on an earlier occasion.
That has attained finality.
It was upheld in appeal.
No appeal was.
No appeal filed. All right.
Come to page 27 of the yellow book, my lord, for a second. 27. This is given by the Sainik welfare. In terms of the order, condition number 1 of the order, in terms of the orders contained in the government order read above, so and so, then Kesav Reddy, who is the second word veteran.
Yes. Anything else?
My lord, I have passed on a brief note, my lord.
Madam, see.
Yes.
Come to page 114. We will, because we have to dictate the order also.
Yes, ma'am.
So see, the thing is
yes,
that the order dated 25, come to page 144 of the original paper book.
Yes.
Now see, in a common order dated 25/3/2004, Honorable High Court has given following directions. Get it, madam?
Yes, madam.
That clause 1. Please read it. Please read.
Ex-servicemen who have been allotted land by
No,
GC.
have been actually in possession of the land. 144, madam, page of this paper book, this WP thing, 17192. 17192.
But we don't have 140. But this. In this, there is no 144. $141. I don't have 144. I will.
Petition paper book.
144 is not good. My lord, I will.
Give madam your copy.
My lord, may I be permitted to read?
We have read it, you read it.
Yes, my lord.
In a common order dated. You without marking, you have given, madam.
Yes, yes. Yes, my lord. In the common order dated 25/3/2004, the Honorable High Court has given the following directions. 1. Wherever the ex-serviceman has been actually in possession of the land and has brought the land under cultivation within a period of 3 years from the date of allotment to JCLCS, the Mandal Revenue Officer shall consider the case and regularize the possession by issuing D-form patta in favor of ex-serviceman or his legal heir wherever necessary. It shall be open to all the
That's all. That's
yes,
all.
my lord.
Clause this 1.
Yes, your lordships. This is
now the documents.
Yes, madam.
Documents annexed with the petition, this yellow thing.
Yes, madam.
Right. Come to page 15. This is a 15 certificate issued by the society, right?
Yes, madam. Page 15 dated 16/5/74, madam.
Whatever. It says cooperative, an officer of the secretary of the cooperative society says that land was allotted to him.
My lord, this is.
Keshav Reddy and he is in possession.
My lord.
Madam.
Yes, my lord.
Please
yes.
understand.
Yes, your lordship.
First, then you will.
This certificate.
We will come to it later. We just want to tell you what is so that you can meet. So this certificate is there saying that he has been allotted land in possession, correct? It is open for you to say that it is forged document and there is no secretary like this. That is understandable. But just come to page 70. He is your officer or not? Taluka cooperative officer.
My lord, my
submission. 1 minute.
My lord, this is belonging to land qualification, which has been suspended.
No. If you don't want to understand it, fine. Then
I'm sorry,
no point in telling. We are discussing, debating upon an issue, and we are trying to tell you, being an officer of the court, thereafter you will be heard.
Very well.
What you have to, you will argue something and sit down, reading something.
I apologize.
We are trying to make you this thing so that you can answer these questions.
True, my lord.
That's why it's not that we are deciding now.
I stand corrected.
We are trying to make you understand what is passing through our mind. So this certificate says that he is in possession of cooperative society, page 15. Then Taluka cooperative officer is your officer, correct?
No, my lord.
No. He is an officer of the government. He says, you said no, he is a government officer. So in this, another document says that this thing, another officer of cooperative society says he is in possession, correct?
This
Then these are the revenue records, whatever he has entries.
Yes, ma'am.
Then at page 27 is the order issued by Government of Andhra Pradesh Department of Sainik Welfare to show that this person is getting a pension of 100 rupees, right? Government itself is granting. If he was not a ex-serviceman, there is no question of granting pension, right? So the fact that he is a ex-serviceman is established because you are granting pension to him. Now comes the decree, page 118. This decree, which was passed on 15th of December 2009, finds him in possession of the land in question and restrains you from interfering with his possession. So forget about those two documents, page 15, 16. But by a decree to which your parties, right, your officers were parties, if there is a finding recorded against them that he is in possession of the land in question, right?
Yes.
And this decree has attained finality, right? So, and therefore, now read page 144, direction number 1, which has attained finality. Just now you read it, again read it. So even though, madam, please listen, what we are trying to tell you prima facie, subject to what you argue. The claim that petitioner is an ex-serviceman or petitioner's husband was an ex-serviceman is substantiated by the fact that you are making payment of pension to him, Government of Andhra Pradesh, right? Second is his claim that he is in possession is, there are 2-3 documents including a decree, right? So he is in possession. Now in that context, he is able to prima facie indicate that he is in possession of the land. Now read this direction 1, order dated 25/3/2004, which has attained finality. How do you meet his submission? This is it.
My lord, my first submission is.
No, first you read it, madam. Submission is fine. You will say something, we will hear, and you have to meet this. Bundle Revenue Officer, there is a direction against him to consider the case and regularize the possession by issuing D form patta in favor of ex-serviceman.
That is the direction number 1.
That applies to the case of the petitioner. This is what you are not appreciating. This, how do you meet this submission?
One step down, my lord, that is condition number 2. There are 4 conditions, my lord, 5 conditions. In condition number 2, my lord, it says it shall
He has
be
submitted
open.
a representation. Do you want to say that he did not submit?
My submission is he did submit, my lord, but that's.
So now you tell us whatever you want to ask.
Yes, my lord.
Please.
The representation submitted was rejected, my lord.
That's why they read petition. That is too basic, right? He read it, no?
My lord.
That you are saying that he is not an ex-serviceman. Are you saying that
No,
he is
we are
not an
not-
ex-serviceman?
No, it is not that he is not an ex-serviceman, my lord. The rejection grounds are he is not one of the members in the list prepared.
That we have seen. There has to be basis for saying so. He is saying that this is without any basis. What is it?
My lord, this page 15, which has been referred and shown to your lordships, dated 16/5/1974.
See, Madam Cooperative Society has been served with the notice. We asked you, no, cooperative, he says, I don't have any idea. Ah, the petition has been dismissed for him. Why? You didn't pay process fee. Dismissed for default as against R6. Hey, we need to have this thing, Mr. Please appreciate you are basing claim on the documents of a cooperative society and see the petition has been dismissed for respondent number 6 on 4/10/2012, 4/11/2012. See, the petition, you have to make an application for recall of this order.
I'll do that. I'll do.
Mark the present. No, we will then, he is correct in saying that I don't have any idea because the petition has been
I
dismissed.
do it, but tomorrow itself I.
Because we need to know the record if you are relying on this.
Date madam.
1 minute. Mark the presence. Learned senior counsel. We will have write an order. Learned senior counsel for the petitioner submits. Delete. Mark the presence. Everybody's presence. In this writ petition, the petitioner inter alia 679, nothing will happen. He will seek time to seek instructions, your senior friend.
No, what I heard from him is, he's saying ex-servicemen alone should get it. So therefore is my.
No, he will have to see, Mr. His stand will go a long way in deciding your fate about documents. All right. Yes. Mr. What is it about?
But is a writ petition filed by the society. Filed by the society minutes seeking cancellation of the assignments made to respondents minutes 7 to 14. At the time when the writ petition was filed, the GOs giving the allotments were not known. Subsequently, the government filed the counter where they said they have allotted. But 7, 8 and 9, 12 and 13 have filed their counters and they have said that they have given the copies of the GOs wherein they were allotted the land. But the other GOs are not available.
What is the prayer in the petition?
The prayer was to
24.
Cancel the allotments.
One. You keep it, madam, this ex-serviceman.
I've given a compilation.
One minute. 1 minute. That was one. No, this 14.9 will granted time. All right.
That's
we will. Let him challenge, madam. Correct. We will, because we were looking at the other order sheet. This is, we had granted 14 September, we had granted you time.
Deeply apologize, actually I've not made it.
Learned senior counsel. You should have pointed out that for this very purpose I have been granted time. We were looking at the other order sheet by inadvertence. Mark the presence. Learned senior counsel.
I appeared 7th and 8th respondent at CRPF. But the land has been assigned in the year to 1994. Since
but like he can make an application for amendment to challenge the allotment, right?
I am the position.
That's point number 9.
On 14/9/2023, this court had granted time to learned senior counsel for the petitioner to
May it please you. Lords, in the first of these items, the second petitioner passed away just about 10 days ago. So we may have to take steps to bring somebody on record. So that's one aspect of the matter. These matters relate to the two water tanks of Usman Sagar and Syed Sagar. The government had issued an earlier GO called GO-MS 111. We are filing a few papers, my lord, which is a brief note on the matter.
This is what PI.
Plus, after 111 was issued, way
So is
back.
it a PIL?
Yes, the bill.
This what is WP?
Mr. Omin Maniksha Dibara passed away about 10 days ago.
No, what so?
We'll have to find out whether somebody else is interested in the matter, what are the steps to be taken? It's because it's a matter of public interest relating to 2 tanks in the city, outside of the city. And the government itself.
9386 is the only 1% Dr. S. Jeevan Reddy.
No, this WP 18896.
No, this is fire. First item is 9386, we believe. And there is only one
Item
petition.
30, man. Item 30, I beg your pardon.
Oh, but what about 25? Who appears? 25? Huh? You are appearing, Mr. Item 25.
Mr. KS.
May I please, madam?
You are.
Mr. I filed a 9386 of 2007.
9386. What is it?
There is a direction to hear that both of them together because it's regarding the same GO. I think your lordship, my lord, have been
GO?
given the brief note, my lord.
Not given.
Because these notes are in both the writs together. Then the note that's my we have to get it.
So what is to be done, Mr. You tell us what you say. You left it at that day he has died. That means it's for us
No,
to
no,
decide what to happen.
I said I'll have to take steps to bring somebody, they bring it out on record.
No, but for the so that we can. What is the issue involved?
The issue involved is, my lords, with regards to, there was a GO issued by the government stalling all constructions within the perimeter of 10 kilometers of the tank level, full tank level. Then the government issues another GO saying, we are reconsidering it. We are saying till you, and this is, they've been talking about expert committees for the past decade or so. That has not seen the light of day. And now the new GO says we are constituting an expert committee. All that we are saying is let the expert committee's opinion or report come before this honorable court, and then your lordship may decide what is to be done in the matter. These are water bodies. Huge water bodies at that.
So, Mr. These are water bodies. There are directions issued by Honorable Supreme Court in Mantri Tech Zone.
Yes, sir.
Yes.
Directions.
Yes.
Those you have to implement. You cannot say that we will not do it. You know Mantri Tech Zone. 2015 Volume 2 SCC at a Mantri Tech Zone judgment. The directions given that what will be the buffer zone of a lake and what all steps you have to take to protect. So this prayer in the first petition is.
That matter went to.
1 minute, you
Yes, my lord.
please
That
see.
matter went to the Supreme Court out of the judgment of the principal bench of the Delhi NGT, National Green.
Mr. Read the prayer clause here in the petition, page 16.
Page 16, yes.
You don't have to oppose everything, right?
No,
This is a future generation, not for us. These water bodies have to be. Just a minute.
Yes.
Page 21. See. Mandamus declaring not taking steps to protect catchment area and area around Himayat Sagar and Usman Sagar. Read it.
There is a 10 kilometer radius. That's what.
What have you done?
My lord, this GO, now, my lord, the government wanted to revise the executive policy. By revising it, government in recent past had given a GOMS 69.
and the provisions imposed in GOMS Triple 1, which they want to enforce it through the court of law. What they say, we are admitting. Till now they say, till that high-powered committee submits its report, these provisions contained in Triple 1 would continue. Yes, we are also submitting before this honorable court by way of counter, stating that the provisions as contained in Triple 1 would continue till the high-powered committee submits its report.
Hey, what is GOM 111? We don't know.
Triple 1, my lord,
This
you are
is final hearing. I mean, this is strange that you are like arguing with.
This string.
How one would know?
Triple 1,
what is triple 1?
These are already there. For the
Everything is there. There is no need for you to stand there also. It's already there.
Yes,
But you appear as an officer of the court to assist us.
I must take part of the guilt on me, my lord, because
Triple 1, your lordship may kindly see. Page number 90. Just for the page number 19 of the
90. There is no 19 here.
of the petition of the writ petition.
We
9386.
thought that he is referring.
Yes.
Mr. Senior Counsel, what is, what is the scope according to you? You have read the prayer clause.
WP 9, I thought I could just say WP 9386.7 was filed. You'll also please to the prayer that seeking implementation of GO 111 letter and spirit and remove such encroachments which affect the inflows into the drinking water sources of these two lakes. These two are the drinking water sources, main drinking water sources for the Twin Cities. So, my lord, and we filed.
You are seeking implementation of 1 minute. You are seeking implementation of GOMS 111, right?
Yes,
which has been upheld by Supreme Court.
Yes, sir.
So GOMS is page. What is one?
Page 1 of these papers, militarization as passed.
March 96.
So you want this thing, implementation of this GOMS 111, correct?
Yes, my lords. Yes,
One addition, madam. What happened was they wanted to amend this GO. We challenged that amendment. That is the next situation where my learned counsel senior.
No, he's saying he will not amend.
Yes, that. We want to amend it because in view of the circumstances that have undergone a sea change, we wanted to revise the GOMS 111 subject to the condition that high power committee submits reports. That high power committee was constituted
when
by GOMS, that at page number 4 minute, that page number 8.
8 of the compilation which I gave.
Page number 8, my lord,
12/4/2022.
Page number 8, my lord, 69 dated 12/4/2022. Just your lordship may have a look at para number 2. Would makes this entire issue abundantly clear. Para 2, as for the details, as the details furnished by HMW, S and SB, these two reservoirs are accounting for 27.5 to 590 of installed capacity of drinking water. When the above said GO was issued, however, since the total installed capacity of drinking water for Hyderabad has grown up from 145 million gallon per day to 602 of million gallon day, and additional 344 MGD is also under execution. As a result, Al's dependability of this reservoir is less than 1.25%, and they are no longer the source of the drinking water supply to Hyderabad city. There are 3, your lordship may kindly see. This makes considering the above facts that Hyderabad city's drinking water requirements are no longer dependent on Usman Sagar and Himal Sagar reservoirs, which was the underlying theme for issuance of GOMS 111 dated 8/3/1996. Government, after careful examination of the matter, have decided restrictions imposed under para 3 of GOMS 111 dated 8/3/1996 are removed, subject to the condition that the water quality of these two reservoirs shall not be impacted any manner whatsoever, and all efforts will be initiated by the government to improve the water quality of these two reservoirs, which inter alia shall include A. Installation of the decentralized sewerage treatment plant.
So this is the validity of this order is under challenge in some of the petition.
Validity of this order.
And all that we are saying is, my lord,
Milord, we have stated in the counter, stating that the provisions, this clause contained in GOMS 311 will continue till high-powered company submit its report, which would lay down the modalities, how to preserve the effluents that would join into this reservoir, how to be safeguarded. Till that high-powered committee submits report, Milord, paragraph 6, that also in GO it's made clear. Page 9, Milord, paragraph 6. The committee shall, keeping the
What has happened? The committee has this thing
not submitted. Committee has not so far submitted its report, Milord. Still, that committee submits report, the provisions contained in 311 will still continue. That is what they're seeking to enforce.
that's what we are saying. Let the writ petition stay, because once it goes out of your lordship's purview, we don't know what will, tanks sink. So keep it pending, let the high power committee take its report, come back to your lordships, and then we decide.
Not opposing that. Let it be. You will submit it.
In the meanwhile, my lord, government is encouraging and authorities are permitting constructions to go on.
No.
Flow of
This
water into this
this
level.
is this is the statement made by additional AG. I mean, and this they can't do like this.
Let it be recorded.
That will.
Huh? Yes. Not be present.
But item 26 is not connected.
26,
27, 28 are not connected.
26, 27, 28 D-link, right? Let the petition be D-linked from WP number 9386 bar 2007 and be listed separately.
Along with
Sorry.
another batch that your lordship's name.
Along with WP number?
There's another batch of writ petitions connected to 26 to 28. The list I'm handing.
It's all right.
There are 17 writ
All right.
petitions.
17 along with these petitions, right? Separately in WP 9386 bar 2000. Continuously, close to the markets will continue. So remaining three matters will continue tomorrow. Yes, Mr. Remaining item 51, 52, 53, because we are have different this thing. These three matters will take up tomorrow. Tomorrow is also working Saturday. Yes.
Well, I'm not there. I'm the item 25 batch.
Batch. Okay. So your case we have passed an order like
Yes.
10 weeks. We hope that it's working Saturday for advocates as well, not only for judges.
That's right.
So remaining cases tomorrow, Saturday. Lunch motion. Yes, Mr. What is it? You said covered, no?
Medical matter, wherein the petitioner has submitted the representation at page number 12, Milan. He asked the authority to permit him for counseling, Milan.
That he did not exercise web option in the first phase of counseling. As per GOMS number 125, Milord is not eligible. But he wanted consideration of representation.
That we can, if you, which page is the order?
Page number 12.
12?
12.
No. Similar order, Mr. Rao.
Milord page,
Page? Not 18. 21.
Milord, this is page 18.
No, not 21. Yes.
Similar representation he has not filed, but those.
So representation, what is your representation?
My representation is
Dated, Mr. Date.
I would like to bring to your attention that.
No, he has not filed representation. He wants to file a representation.
Well, he already filed the representation.
Where is that?
Copy is not there.
At page number 12, Milan, exhibit P1, Milan.
Date.
Date is 18th September 2000.
Email. Arey, Mr. Rao, email 18 September. Mr. Madam, yes. This is the only change here. Page 21, disposed of. Copy today. Yes. Yes.
Page number 25, order your option.
Yes, Mr. Rao.
To consider it. Page number 25.
Page 25, madam. Disposed of. Yes.
Page 26, Lordship, the orders.
Page 26. Item 3, page 20. You get others, madam.
Page 23, Lordships.
23. All right. Disposed of. Yes.
Page 28, Lordships.
28. Yes.
Lordship, this is slightly different, Lordships. This is the case, Lordship, where petition was allotted a seat.
Oh, what about 7, 8, and 9?
There are covered matters. There are representation.
7, 8, 9, 7, what page?
7, Lordships, is item 20, page 26, Lordships.
Item 7.
Page
26, madam. Right? 8.
33, Lordships.
33. 9.
25, Lordships.
25. All right, certified copy today. Then what? 0, 1, 2, 3? So 1 is missing, right? See, 0, 1, 2, 3, 1, 2. 10, yes.
Page number 25.
Page
25.
number 25. 25. 25, madam. Certified copy today.
26, my lord. Page
26. Mr. Rao, correct?
Page number 24, my lord.
Item 12, page 24. Got it. Certified copy today. Which other?
Page number 25 now.
25.
Page 28, Lordships.
28. Yes. Copy today. Yes. Now what? Yes. Now we come to item 6.
But it's slightly different. But here is a case of petition was allotted a seat, Lordships, in Deccan Medical College. Lordship, what are the, in last year, Lordship?
Allotted a seat in?
Deccan Medical Sciences, 4th Respiratory College. This year.
This year.
This year. And I have to submit my original education certificate by tomorrow 2 p.m. 23/9/2023. But earlier, last year I have joined in BDS course. My certificates are with the Pananiya Mahavidyalaya. We file a writ petition to release the certificates. The writ petition was allowed directing the college to release the certificate.
They order dated
Lordships, that is at Lordship case 27, Lordship, 31st August 2023.
31st August
2023.
WP
24177 Lordships.
24177. Okay.
That your Lordships get page 30, Lordships, your Lordships get the order. 31
So
Lordships.
the college you have impleted, right?
Lordship, I have impleted the college which where I need to submit my certificates. Lordship, fourth
Deccan College.
Deccan
College. Mr. Rao.
Well, my submission lordship says, Milord, he has taken admission in a private medical college under management quota for the academic year 2021-22 in BDS course. After pursuing 2 years of course, Milord, he again wrote NEET examination, he could get MBBS. He wants return of the papers. But GL rule says, Milord, a statutory rule says, Milord, if a person discontinues the course, he has to pay the fees to the university. But he doesn't want to pay the fee. About 42% discontinued, all of them paid except the petitioner. Because it's only to prevent, the rule was incorporated to prevent seat blocking.
But let him be admitted, he will lose his seat. That issue, whether he needs to pay or not, can be decided later. We are at the interim stage, we are issuing notice to you. File response. We are not deciding this. Heard on the.
Well, Palani already paid the direction.
Already given the direction to the college to release the certificates. Now, tomorrow is the last, they have not released the
Milord,
certificate.
is only Milord seeking extension of time. Milord may grant extension of time. Who will Milord pursue that red petition?
Oh, so how much time do you want?
Lordship, Lordship, I sought for 15 days time, Lordship, because we already initiated contempt for not releasing the documents.
Right, 15 days, Mr. Rao. Yes, mark the presence with consent of the parties matter is heard finally in this writ petition. Medical Sciences, the petitioner, respondent number 4. Nine 2023 paragraph. It is pertinent to note that the petitioner was admitted to BDS course when in academic session 21-22. In which college?
Pananiya Mahavidyalaya, Lordship.
Pananiya Mahavidyalaya. Full stop. The aforesaid dental college has retained the Pananiya, Pani.
Can have.
Let the writ petition be pending, my lord, so that the appeal and this could be decided, my lord, one. My lord, interim order, my.
You said that time be extended, that's the only prayer. That's the only prayer in the petition, Mr. Rao.
Can have a copy today, Lord.
Today. Madam, go, you type. Not there.
course, I was instructed to appear, but require some more factual aspects to be mentioned. But then today, some more facts which had happened subsequently.
You are praying for adjournment. Next week.
I need an interim order from the government not to interfere with her.
No, but then you will have to argue.
Very well. I'll just start. The writ petitioner herein is claiming land to an extent of 32 guttas in survey number 57. That he is an agreement holder with possession from one of the shareholders in the different number 14 in CS. And what has triggered, I'll just point out, Lord, Lordship may kindly have a look at page 238. Page 238. Lord, this is the letter addressed by the collector to the regional deputy director.
Ideally speaking, you should file a suit for permanent injunction.
I'm not. Today,
not read petition.
But today the interference is from the Tehsildar under the guise of this.
He is bound by orders of injunction passed by civil court also. He can't say.
On page 238.
What is the order passed by Supreme Court?
Supreme Court, that is an appeal which was filed.
No, so you claim that you are in possession of some land, Tehsildar is interfering.
At page, right. That is under the guise of this page 238. But this is only because again connected to this. Even if I go elsewhere. Just have a look at page 238. That would make it.
This is a WP. We would see this. Tells us how to look at. We will make it clear further. Interesting. Yes.
But page 238. Now, what is happening is the collectors are now issuing directions for taking over possession. This is one classic example, yet another classic example. Page 238, Your Lordships. Now, this is a letter dated 24/5/23, addressed by the collector to the regional deputy director. Kindly turn over note page 239. Now, this is an application filed by on the representation of respondent at serial number 8, 22/5/23, and beginning from 25/9/22, which is at reference number 1. Now, Your Lordship, kindly turn over page 239, the penultimate para. Through reference 8 cited, Sri so and so has submitted representation and stating that required to enter into the physical property, scheduled property, for taking over the physical possession of the same by fixing boundaries to the scheduled property, and the same is possible by fixing boundaries of the scheduled property with Traverse Survey and Shamshiguda village. In view of the above, it is requested to conduct survey of the land situated at Shamshiguda Kotpalli and to prepare and furnish location sketch and subdivision records for taking further necessary action. Now, pursuant to this, they come at page 6, Your Lordship, page 16. I asked them without notice.
Same this, no? Some other party. Have you gone through the report filed by the Advocate Committee, CS7?
Yes, we have filed objections.
File objection to that.
We've already filed it. No, this is a separate call option. The other reason I wanted to point out is, which is not gone out of the record, which I am aware because I appeared in the connected matter when they instructed, I came to know. Lord, the respond number 7 and 8, they say there is a final decree in their favor so far as this CS risk property is concerned. That was appealed in OSASR 6832 of 2015 before the Honorable Court. But I confess that it is not part of the record, but it is a part of this Honorable Court's record.
Hey,
I believe
Mr. This publication is under challenge, right? You have also challenged, no?
Yes, I have challenged already. Second is the one.
That's what we were discussing, that probably this language of this, we have seen it somewhere, then we remembered.
So in fact, what my learned senior is referring that OSA order, I filed Miller.
Okay. Yes, yes.
That is on 2/1/23, this Honorable Court granted interim status quo to be maintained. That went to the Supreme Court. Supreme Court again suspended that order. So it's still, OSA is still pending. Stayed. They said stayed. Further proceedings are stayed. So the order of suspension will operate. Today they can't take any action under the final, so-called final decree that is in their favor, which I have filed at page 276. And the final decree, page 276. But be that as it may, even if they want to take possession, but the collector can't direct. They can do survey without interfering with anybody's possession, without disturbing the possession. Probably if they want to identify or demarcate the property, that it may be permissible. But not that one who is in possession you dispossess. That is where we have a grievance. Bringing bulldozers. Survey again, in fact, the survey should be conducted within the.
Oh, you are opposing. Yes. Friday, Mr. Prabhakar. Yeah, because.
No,
All right. Next week, Mr.
You were not on
with
your
case also.
KV.
My case is there not today. Next case is only.
All right.
Case is only my case.
Mr. Prabhakar, learned senior counsel for the petitioner. He shall not be dispossessed till next date of hearing except in accordance with law.
Yes.
We really don't know whether they are in possession.
Let me peruse their report because my client's business are involved. I'll find comment.
I'm only seeking a direction to the government at page 16. The government. But then in that event, there is no reason why they should come to this land again. 16 and today, let them maintain status quo as on today.
But it same page 24 in the next part. And that has already been acted upon.
I would also, I may be permitted to add two aspects, my lords. As the grievance that was ventilated is the title set up by the petition is under an agreement of Selcom GPA. And my lords, that is from defendant number 14. Admitted case of the petitioner is that his applications are pending, my lords, for consideration for final hearing. Let's he request this court to direct the advocate commissioner to, my lords, fence the property. That itself shows they are not in possession. And their grievance at page 15, Lakshmi C against private respondents. As per the complaint which was addressed, page 15. Page 19 is the, my lords, their prayer to permit the receiver commissioner to fence the final decree. This is their own application, they are pending. And admitted case is there. It's an agreement of Selcom GPA.
Coupled with possession.
239 page which was referred to. Mr. kindly look at the last paragraph. That was the request of the respondent number 8. But the ultimate directives of the collector is, in view of the above, it is requested to conduct survey of land situated so and so and to prepare and furnish. There is no direction as such to dispose them. And photographs my land friend has filed.
Page 16, 16.
15 is the complaint against private individuals, my lords. Page 15. And cause of action was shown as page 15 and paragraph 11 merits of the affidavit. This is the complaint against Sripad Deshpande and 20 others who are said to have been, and they admit in this complaint that their application for final decree is pending.
In fact, para 11 at page 12 of my affidavit, I have also said about the Tehsildar. I said, their own officials. No, your lordships may say, let them conduct survey. They will not disturb the constructions. That would be enough, irrespective of the possession. But that would safeguard if they are in possession, they will continue.
In the same 38, that is actually 24, the other learned and learning. And the position was that kindly have access to these papers.
Yes, I have.
Both matters can be heard.
Please go, madam. You are sitting here. You have to type everything. No, you go. You have to type today orders. You are sitting here. Yes.
Both matters can be heard because my interest is affected and indirectly it's part of the government agencies and actually making us. Yes, but I don't know. I haven't seen it.
Same page 230. It is the same order. Same thing. Yes. Yes. One minute, we are there. We will come to your case later. Yeah, we are. Hey, how can you comment when item number 1 is being taken up? Your case is not being taken up. Relax. Yes.
No, is apprehend. Is it?
Who knows who is in position? This survey has been conducted.
Yes, my lords.
Oh, why don't you place on record that copy of survey report?
At one point of time.
No, no,
the
so-
results were back by the government, which was in our position. What happened when the 150 was passed in favor of Smart Center? Government.
See, Mr. Prabhakar, one this thing, and what we is passing on in our minds is that this all disputed questions of fact in a writ jurisdiction, whether or not you are in possession, where is the land, what is it, whether he is in possession, this all in a summary jurisdiction under Article 226, we are by way of an ad interim order, we are required to record a finding that you are in possession and therefore you will not be dispossessed.
Yeah, I quite see the,
That is the predicament. But my brother rightly pointed out that even if we are the civil court for the purposes of this suit. So therefore it will come to us only. So I was wondering that,
that is what is my, because even if I go to a civil court, the difficulty is there are several orders from this court, there is government there, section 80 notice will have to go, but there, today all our doors are closed except this is the only window we have.
Wait for 1 week.
But I may make one submission. But they are saying,
you
sir,
see,
survey is completed.
1 minute. This P10 was issued on 24/5/23. You have waited for.
No, I was not
nearly
aware
4
of
months.
this. They came only a few days back. That's the problem. Now, they make one submission, subject to what my friend may not disagree with one side, make a suggestion. But what I'm saying is, according to them, survey is completed. But I'm still saying, let them come and enter my premises. I have no objection. But let them not use this bulldozers for this. But why do they require a bulldozer for the survey? Unless there is something else in there. I have shown at page 16. But they are supposed to come with some cadastral instruments. Well, let that part be not resorted to for a week. Well, they can always take dispossession action after some. No, I am saying.
Degree was passed in favor of Islamic Center. Government challenged the degree that was dismissed.
I am sure my friend is not suggesting that JCBs are required for survey.
Council, do you have any title for this property? Any copy? I'm asking.
I am also one of the.
You stated at para 3 that you are only in possession and enjoyment.
No, I am an agreement holder come with possession.
Para 9 Malats, title Malats was para 9.
There are two aspects to it. Right or wrong, I am in possession according to me. I have filed documents to show that I am in possession. Number two, I am saying that there is no order from any court permitting me to be dispossessed by them, by somebody. Number three,
there is no order by the collector to dispossess you.
But that is what, but page 16 I am showing. Let them say that they are not coming. If it's only a private party, I can do it. I will deal with them. The manner in which they are required to be dealt.
You are at risk. Now, he can deal.
Let the government not do all this. Let it not resort to. No, I am not saying under the guise of. You are doing it under the guise of the government support. I don't want.
Yes, council, when the final degree proceedings are pending, where is the question of title? Who has the better title now?
That is what is to be decided, yet to be decided. Nobody has title. Whoever is in possession will continue. Nobody can claim of absolute title. That is the subject matter in USA. The Honorable Court suspended it. That's what I am told by my friend. By the instructing. In fact, I had appeared in the connected one WP 33492/21 where I had appeared and status quo was passed by Honorable Court. That is relating to the adjoining land, not this land and this respondent. I may also say that. No, that is a. I see.
So at least, no, whatever superstructure appears at page 16. See, whatever, page 16. See page 16, what we are saying is, till next date of hearing, let those superstructure exist.
That's all.
And be not demolished. That's all. Whosoever it belongs to, it may be yours also. Page 16, please see photograph.
16:16.
There is small sort of a temporary hutment sort of thing. Hutment sort of thing, right? 16.
17. 21. No, that's not,
Belong.
The subject property also, but in your fairness, I think to show this my client. Take instruction. We are living in a world where the photograph,
That's why I'm saying I'm not even requesting that the survey should be stopped. Let them do by all means. They can't do anything beyond the survey even as per the letter.
document like this, for a petitioner, declare any order. Yes, establishing. And I have passed out by the letter government that their agreement of state of possession is so final degrees passed.
That is.
They have received to raise the property in legal possession. I don't know what, everything is arrested in an accident.
That is for the larger extent.
Next, Mr. Prabhakar, next week.
Next week, I
All right, so notice on behalf of so and so advance notice. Don't say notice, right? List on next date is what?
I am only saying whatever survey.
Can we say with reference to land survey number?
Let them
instead of not photograph.
Yes.
The survey number 57, the lot as far as we are concerned, but our land extent of 92 acres has been added.
No. Whatever is superstructure is there, it will remain with you.
Yes.
It should not be demolished till next date. Can we say that it will be unidentified. We will give you damages, Mr. What is this? If the government watching this, what is the value of that?
The difficulty is this. I would not be opposing this. The difficulty today is even in a land acquisition matter, we are not able to recover for decades. And your lordship knows in a private common law remedy, 2 generations of lawyers will pass. Forget about the parties.
No. What is the value of the?
It's not value,
no, we are asking you.
It's not be much.
How much, according to you? 1 lakh.
Maybe that
at the most.
But then
we will ask him to deposit that
the issue is, the issue is under the guise of that, if they raise the whole ground, nothing remains there.
No, Mr. This is.
How can they demolish a structure under the guise of a survey? That's a question that I put to myself. And the very fact that my land friend is vehemently opposing would show what is it in their mind. No, otherwise, that survey is to be conducted and you say that I will raise the structures.
They have made a request to the receiver, fix the land,
Next only fence the land.
Why did you say 6th October? It's 29th September, right?
Next Friday.
No, next Friday. You said 6th October.
I thought.
No, 29th September.
I'm sorry.
29th September, right? Next, just 4 days away.
Anyway.
One of them, this thing. 29th. That's why we. 29th
Anyway,
Friday.
I'm sorry, but I thought.
No, 29th.
You missed dates.
29th September, Mr. Prabhakar. We will hear that next.
Credit goes to my friend. He has derailed me so much that I forgot the dates. Oh, bless.
All right. Yes. No, no, we have clarity, mister. You are arguing on admission for past several dates, right? We have reduced it into writing also your submission 1, 2, and 3. And you feel that we are not clear, but we are clear. If any confusion, you tell Supreme Court if it goes against you. We don't know at present. We have recorded this 8/9/23 order. We have heard you so many times that we remember the as the order immediately that we have seen it. That shows how much attention we have heard you. That only shows that. Notice dated 24/5, district magistrate has directed to conduct the survey. No jurisdiction to direct. Permanent injunction been dismissed. Circular have you filed 25/7 when? Madam, 25/7. 1. Yes. Last date. Same is not on record. Yes. Where is the circular, madam? Memo 25th July. Not the one. When have you filed? No, counter is fine. He said that on 14/9 you have filed. When? So no. Mister, we want to wish to tell you that the office notice that USR number 90808 dated 14/9/2023 verified entire bundle circular dated 25/7/2001 are not found. You give that us to They have written. We don't want to. There's no point in joining issues, asking you to file an affidavit and prove you correct, prove registry wrong. We should decide this, no? You are only saying that it has no jurisdiction to issue notice. Or 25/7. Which provision? That's all. You want your copy back, right? Yes. Otherwise, it will not be possible for you to what to read. Read the relevant portion, mister. This runs into 10 pages. Page 3. Page 3. Paragraph 4. Yeah.
Of man being primary and surveyor, even the demand to private party officer DD and under surveyor shall conduct the application after written approval of the officer concerned as to any matter and mandal pattern spreadsheet. Implement the surveyor, participant by constantly so is that for reducing the the surveyor. Thus, the educational officer should represent first only and
So this is one, right? 4-1. A Mandal revenue officer has to do it. So that's it, right? The thing, this is what you're relying. 4-1 Mandal revenue officer.
And
8 and 9.
No different in have been accepted after directly by passing the directive of the officer. In case it's not partial. It should be needed in the return to the party advising.
All right. So one thing, more thing, Mr. We have understood this. Huh? So one more thing is that these instructions have been issued in exercise of some statutory power. Which?
Yes.
What is BSO? What is BO? What is? We have seen para 20 of BO 34A. What is 34A? So BSO, what is standing order? Framed under which provision? Right, Board of Revenue may have powers to issue executive instructions or statutory power also. Like, is it an instance of a sub-delegation of power that this is administrative instructions, right? Executive instructions under Article 166, right? Sort of this 25 July 2001, no statutory force. No, nobody is challenging. You are relying on the validity. We are only asking whether it's a statutory force or not. Executives. Yes. So we have understood that under these executive instructions, the Mandal revenue officer alone has jurisdiction, right? Fine. What else? And other, you have already argued that garb of survey, possession of land cannot be taken. And then you have told that suit for permanent injunction filed by respondent Braid dismissed and decree is affirmed in appeal. And therefore, they have no right in law to seek survey of 57. Correct? It's not, things are not that difficult which they appear, right? Like, then what else? We have understood. What else? Don't you think you should wait and see what they have to argue, then submit a rejoinder? Let them, that's what we are saying, that you please, we don't know what they will argue, right? Let them argue, then it's better know that you can give a rejoinder reply. What last night? We don't. Have you supplied a copy to the other side?
Last night, also
Acknowledgement. Then please do not refer. Or then you supply them and then we will hear it. No, no, Mr. Then we will not rely because then you, so we are not relying on these documents, right? Because you have not supplied a copy. When have you filed that memo? We will have to write in the order. Memo dated 22nd September 94074 of 23. Yes. Counter. We are telling let them argue. Yes. Para. Yes. Rate affidavit submitted that. Redeliver, restore police. Yes. Arey, madam, we are. There. Yes. Mr. In this writ petition, you have challenged the validity of the notice, that which has been impugned. We are not going to record a finding who is in possession. Three grounds we have recorded in the order dated previous order, right? After hearing you at length, we are not going to record a finding that you are in possession or 7 and 8 in possession. You are reading it. He may say that respondent number 7 is Vice President of India. So do you think that if he says that respondent number 7 is correct, we are not going to decide. That is not the scope of. We are only deciding this. Neither question of title nor possession we are deciding, Mr. This is outside the scope of this writ petition. So therefore they cannot seek survey since they are not in possession. This is the submission. We are not, Mr. We are not saying that they are in possession. That should put an end to the matter, right? We are neither giving a finding as to who has the title, nor we are holding that who is in possession. That's the end of the matter. Yes, go ahead. We are. So they say so, that is all. We are looking at you. You are looking at us. So we should look at each other for next 1 hour and then end of the matter. It's a very convenient position for us. We will not be required to write an order. This is this much of argument on stay, right? So when the matter comes up for final hearing, what will you do? We don't know. Yes. We have heard you on admission, Mr. There's no question of stay. We have heard you on admission. Then only if the writ petition is admitted, then the question of stay arises, right? We have heard you on admission. Petition has not been admitted for hearing. Yes. Yes. What stay you are seeking? Ah. Stay of memory. 8/5. 8/5/23, right? Yes.
Yeah. My lord,
Ah,
as
yes.
far as, yeah.
Yeah, they should, it's their baby. Yes.
But subject to filing of counter, my lords, I just make submission.
But
The challenge, my lords, in the.
We are hearing, see, he has made it look like a marathon exercise, right? Because according to him, the value of property may be in crores. So he is arguing as if there is this thing like, it's only on admission, Mr.
That's correct.
He could have been brief and concluded within 3 minutes. But that is what it is. He is arguing, and we have made notes also. So then what is, it's on admission. It's not.
Thus, the challenge in the writ petition is a memo issued by the collector.
Therefore, you have heard, no, that it is in violation of the guidelines.
Circular, my lords, circular has no application in this present case. My lords, for the reason, my lords, initially, my lords, survey was, my lords, report was called for from the Tahsildar.
Why it does not apply?
That is what, my lords. Initially, a survey report was called from the Tahsildar itself. Plus, after.
Where is it?
Plus that I'll have to place, my lords, before your lordship along with my counter. I have received instructions, my lords, basing on that I am reporting.
What has happened in pursuance of this 8/5/23, 24/5/23?
My lords.
The survey has been conducted.
Conducted, my lords, on 12/7 and 15/7, my lords, and it was concluded on 26/7.
12/7 to 15/7 survey conducted.
Conducted, and it was concluded on 26/7/2023. Let's initially.
No, where is the report then? 27/7/23.
Yes, 26/7.
26.
Concluded.
No. So where is the report? Survey report.
It was forwarded to Commissioner and Director on Survey and Settlements, on 18/8.
You produced the survey report if that is so. And how is it this thing?
Circular has no application for the reason after Tahsildar has submitted his report, sketch map, the district collector has noticed that there is a boundary dispute between 3 or 4 villages. That namely Bachipalli, Shamchiguda, Agameri and Ramaram village. That is the reason why he has directed the regional director to conduct survey.
Page 25, it is there.
Page 25 proceedings. Since there is an overlapping issue with respect to 4 villages, he has directed the regional deputy director to carry on the survey.
But who is then? He says that as per circular, MRO alone is competent to do the survey.
Provided.
MRO is Tahsildar.
Tahsildar.
MRO is Tahsildar.
Yes, ma'am. The collector initially called for a report.
And then
from the Tahsildar.
Regional deputy director. This.
Yes, ma'am. Regional deputy director's jurisdiction was invoked for the reason, there was.
No, who is he? He is Tahsildar. No.
No, Malars.
Who is he?
But original survey, as I understand, was done by Tahsildar. Then as there was a boundary dispute,
No,
instructions.
we are asking who is the regional deputy director?
He is a higher officer.
He is Survey and Land Records, Malars.
Survey and Land Records Office.
Huh?
He is an officer from the Survey and Land Records Department.
All right. The survey was done by whom?
Regional deputy director.
Not regional.
Initial survey was done by.
Inspector of Survey, Mr. Who has done the initial survey?
Plus Tahsildar has submitted on 3rd March 2023 to the collector along with a sketch map. Collector, after examining it, my lords,
Where is the survey report, Mr.?
I'll submit.
You submit on the next date, next Friday.
In fact, I have also applied for it, but.
No, we are directing him to
My lord.
submit. This thing is prayer. Learn it, mark the presence, learn it, whatever, comment, please. Next. He has been discharged. No orders. 8, 9. In view of order passed on 8/9/2023, no further orders required on the communication which has been registered.
Well, in item 129, I appear for the respondent writ petitioner. Well, it's an appeal filed by the state, intra-court appeal filed by the state.
Complete petition, who has filed?
I filed it. Complete petition is filed by a third party who was not a party before the learned single judge.
It was, my lords. I'm sorry, with great respect. to
1 minute.
The cause title doesn't show.
Okay.
If he is a party, he is asking for leave for filing an appeal.
All right.
I'll satisfy, my lords. That is the case.
So what is to be done? This is for IE.
The only hearing of this writ appeal, my lord, I have circulated a short synopsis of 2 pages. This is a case like this, my lord, your lordships have also made it a part of the notes. The writ petitioner.
No, their appeal, right?
Their appeal.
So let him answer first. This is to be heard finally today.
Last occasion they were saying that all CS 14 matters are under status quo order passed by the Supreme Court. Then your lordship directed them to file an affidavit to that particular effect
enclosing the order of the Supreme Court. There is no such order, Palit. Their
We have
statement
filed an affidavit,
is not
my lord,
correct.
with respect. As we have filed an affidavit on 31st August 2023. My lord, mentioning the my lord, SLP numbers which are pending as with respect to Hafizpet villages. My lord, at paragraph 7 on 31/8 we have filed the affidavit. We have stated, my lord, the SLP numbers with reference to, my lord, the Hafizpet lands.
No, so what do you say? I mean, is there a stay?
Status page 19, my lord, is the order copy.
Where is? At page 19 of your affidavit?
Yes, my lord.
Affidavit, madam.
And now, my lord, the matter was listed on 31st August. And
No,
it was
please read the order of the Supreme Court.
So SLP is pending before 7154.
Page 19, he is referring to, my lord, SLP 7154 of 21. Is that so?
71542635.
Directed against WP number 12548 of 2020.
So this has to be heard, right?
It has to be heard finally, my lord, sir.
No, this appeal has to be, my lord, 2016 writ appeal, my lord. Learned single judge, direction of the learned single judge is this much, my lord.
No, we'll
Granted
fix it,
me
Mr. We'll put them to notice. We'll fix it for final hearing next week only. Right? Let the appeal be, let learned so and so additional advocate general, right?
Representing additional advocate.
Whatever submits that he in compliance of the order dated 18/8/2023, he has filed an affidavit. Let the appeals be listed for final hearing. Next is yes.
Yesterday, one more implead application.
All right.
Yesterday, we were served with another implead application.
Oh.
Implead application.
That only shows that perhaps senior counsel is right that we should decide it before others implead.
Well, see, in my implead application, another implead is filed.
Implead application with implead application.
Because this is a case, your lordship.
I satisfied my lord. My lord,
Hindustan Aeronautical Limited Society, Ramavataram, one person. Another matter, my lord, your lordship heard. There is an internal fight among us, this particular society, HAL society. And one person says that he is authorized to represent the society. Another person comes forward saying that the person does not have the authority of law.
but
This is, the learned counsel is yes.
the fact remains, my lord, we are the owners. HAL society is the owner.
If they are the owners, they will have the right of.
All right. Yes. Yes, Mr.
But I appear for the ninth respondent.
Yes, sir. This is connected. I'm sorry, my lord.
Yes.
There is a connected matter, 5348 of 2023. Both may be taken up next week, my lord.
5348.
Yes, my lord. Yes. Of
Yes,
23.
Mr. As paid by learned counsel for the petitioner's list for analogous hearing along with WP number 5348 of 2023.
Deeply obliged.
Yes.
But there are
In the next week.
I'll give the slip.
Yeah, list along with WP number so and so and 2 more petitions. Yes. The next week.
Deeply obliged.
130. Yes.
Appeal for CH Ravinder request for next week, like connected matters are there,
Praise for adjourn. Why? He is not well.
He is not well.
Learned counsel for the petitioner, whatever, write her name, praise for adjournment on the ground that arguing counsel, Mr. CH Ravi. Contempt. City Civil Court appeal. City Civil Court appeals. We thought it's contempt. Early date. Yes, it needs to be heard, right? No, no, not this, there is an IA to fix an early date. This is 2012 matter. It needs to be decided, right? So that you 16th October, Mr. Senior Counsel. 16th October for final hearing.
13th October, Lord.
13th.
Because there is a lot of problems.
Friday. Oh, yes,
There are 4 appeals.
yes,
There are
yes.
first appeals.
First
There is a
appeal.
voluminous record is there.
Yes.
It is not as though there's something like writ petition, we have to say something before the court and like that. At the government pleader, they said that they will give some note also.
Note.
So far, they have not given any note also.
He is praying for time for note also.
Therefore, Your Lordship may have done 13th October, let
No,
them
no,
give in.
law pleadings have to be adhered to.
I'll leave it to
Writ
you.
petition also. It cannot be like that they say something. And RFA is nothing, white extension of a civil suit, judgment and decree, you get most of the everything.
6th of
Heard on IA 1 of 2018 an application for fixing an early date of hearing. Take That's all.
In fact, long back, I have made written submissions also. Also.
You keep the written submissions ready.
Whatever they want to give, so that we will know what is their stand now.
Yes, yes.
Definitely. Not only government pleader, there are 2 more appeals are there. Parties.
What to do? I mean, that's what we are telling him, that one time investment, Mr. Do prepare the case, right?
We'll do that.
Give us this thing so that, and go through his written submissions also. Learned council has submitted. None for respondent, right? The respondent was granted time on 11/8/2023 as well as 18/8/2023 to file counter. However, neither the counter has been filed nor anyone is present on behalf of respondent. Third finding. In this petition under section 11 within bracket 6 of the Arbitration Conciliation Act, the petitioner inter alia seeks a direction to appoint an arbitrator on behalf of the respondent, and the arbitrator appointed by the petitioner as well as the one nominated by the court be, be, uh, and the arbitrator appointed by petitioner and nominated by this court be directed to nominate a presiding arbitrator for purposes of constituting an arbitral tribunal for adjudication of the claims and disputes which have arisen between the parties. Paragraph facts, madam, I can see that counsel either this side or that side. To appear now, everything is over. Now you appear before Supreme Court. Nothing. This is, Madam, please do not convert these 11-6 proceeding into a civil suit, right? Suit for injunction pending for 20 years, right? It's all speedy resolution of dispute. Two opportunities were granted You don't appear. Obviously, you have been told to run when you learned that the order is being dictated. So you ran towards this court, and also this order will not be recalled, whatever you say. Huh? We can, at the most, we can mark your presence back. Or none has appeared, delete. Huh? Counter has not been filed. And then you say, we have heard, I have heard both sides. Huh? Learned counsel for both sides, and then the order remains the same. So we have appointed Justice Kodandaram on your behalf, and Justice Justice K.C. Bhanu. They will nominate a third presiding arbitrator and will proceed whatever. Yes.
And I am appearing for the respondents, Millet. My apologies, Millet. Last time, Millet, last week, my colleague has appeared and she has noted down that the matter has been adjourned by 2 weeks, Millet. But
No, this
one final opportunity, Millet.
No. Counter if any on or before next date, failing which
I have seen, Millet. I have seen that.
What is this? I mean, you want to say that your colleague doesn't understand anything conveniently in her absence?
No.
Who is he? Who is he?
Srimati Usha, Millet. She is appearing in other.
Like she, in her absence, conveniently you are making a statement.
She agreement is admitted. Dispute resolution mechanism is admitted. Invocation is admitted. Because they want to let them go before arbitral tribunal, Millet. It's only transfer chair and SPV. Very
correct. Yes. Mark the presence.
We are entitled to raise all the.
Of course, this petition under that is, even if we don't say,
yes,
this petition under 11 within bracket 6 of the arbitration.
High Court judge of this. I leave it by. I don't have any say. So
No, what is the dispute quantum like?
12.5 crores, my lord, plus interest.
So normally you better know, we appoint Supreme Court judges.
I leave it to your lordship.
No, normally,
normally not, Millet. Normally not depends on lordships.
They may say so.
We had always suggested a Supreme Court judge. I thought any Supreme Court judge would be. There are instances where I leave it to your there are instances where after appointment there is no Millet.
Like Mr. Justice P. Naveen Rao, a former judge of this court, is appointed as sole arbitrator to adjudicate the dispute between the parties. Needless to state that it will be open for
I appear for the petitioners in this matter.
Yes.
The notices are duly served, my lord. Proof of service is already.
Nobody is appearing.
One Mr. K. Ravi Mahendra is appearing, my lord. His name is printed in the cause list.
So shall we take it up on next date so that we can proceed? Right?
It's a admitted case. There's nothing much. They've ended up here. It's quite a long time ago.
But we will have to then pass over then. All right, pass over then.
At the end of the list.
At the end of the list.
Obliged.
It's after list, this thing notice it is coming up for the first time. That's why we said next date. It's better to say.
Obliged. But the notice is out quite long ago. It's a 1-year-old matter.
You are an outstation counsel.
No, my lord. I'm an.
Then
Obliged.
no difficulty. Next Friday you can come to the court, right?
No problem.
All right. None for Mark his presence, none for respondent, even though notices have been served. None for
So I appear for respondent in this matter. So I need to file my counter, my lord. Lordship may have it after 2 weeks.
2 weeks.
Next week is also fine.
What is there? 11/6 nothing.
I'm just looking to my lords because factually they have made some.
Case for adjournment to enable him to file counter list on.
My lord, so I bring for the respondents.
Filed counter.
Counter not filed, but my clients are suffering with a viral fever. They could not contact me, my lord. I'll submit my lord arguments, my lord. Other side.
Yes. Other side is not there. None for petitioner, Mr. So-and-so for respondent awaiting appearance on behalf of our hearing is deferred.
Obliged.
Yes.
Lord, my colleague is appearing online.
Oh.
Yeah, just.
Yes.
May I please, my lords? So, my lords, this is a petition under 14 and 15, my lords, of the Act. Now, my lords, if my lords may
Mr.
Challenged it on the ground that it is a unilateral appointment by the government. They are in front of my lords, my lords. Our only submission is that plea could have been taken in front of him. Plea could have been taken.
No, but this thing 12(5), you know, amendment. How can you appoint this things?
That's the sole point.
Then whom should we appoint? Who is appearing?
Yes, my lords, I am appearing for petitioner billets.
Fine. It is in contravention of 12(5), right?
Yes, my lords. After the Supreme Court, my lords. So, my lords, I only pray, my lords, that this honorable court may please to appoint some independent arbitrator, my lords, or transfer the matter to arbitration center as my lords deem fit.
All right, a former judge of this court. Venue is Hyderabad, right?
Venue is Hyderabad.
Yes, my lords.
All right. Yes, mark the presence.
Deeply grateful.
Consent of the parties heard finally in this petition under section 14 and 14 of the What happened? This petition under section 14 and 15 of the Arbitration Conciliation Act 1996 has been filed.
This matter, your lordship, item 1.
This petition under section 14 and 15 of Arbitration Conciliation Act 1996 has been filed to terminate the mandate of Shri Atul Khare as sole arbitrator paragraph, and I have heard learned counsel for the parties at length. Admittedly, Shri Atul Khare is an employee of the respondent and his appointment is in contravention of section 12 within bracket 5 of the Arbitration and Conciliation Act 1996 full stop. Therefore the mandate of Shri Atul Khare as sole arbitrator is terminated. Full stop. Mr. Justice Kodandaram, the former judge of this court, is appointed as sole arbitrator to adjudicate the dispute between the parties. When will you appear? 30th September. The parties undertake to appear before the arbitrator along with copy of the order on 30th September 2023. Accordingly, petition is allowed. Yes.
Deeply obliged. Deeply grateful.
Madam, you 12.5 of the act which reads as under, right? Code 12.5. Yes. Ordered. Served.
Copy, sir.
Then don't. Yes.
Let's I appeal for the applicants in this matter. The notice.
What happened? Notice served.
Service is also filed, my lord. None appears.
The same order, 29th.
Pleasure.
None appears. It is made clear that despite service of notice, none has appeared on behalf of respondent. It is made clear that in case no appearance is made on behalf of respondent, the appropriate order shall be passed. List on 29 September 23. Yes.
Similar, my lord.
29 September. Yes.
Obliged.
Yes. Who is appearing 148 to? This is showing Madam 145. That's why we count.
Lord, item 148, Milord, counter is filed, Milord.
Counter is filed?
Yes, Milord, counter is filed in the last judgment. Your Lordship can appoint any arbitrator, Milord. The quantum involved is only 2,65,000.
Who appears? Counter, Madam, where is 148 to 151, all the cases?
In two cases, Milord, rest two cases served but none appears, Milord. In this case,
Which cases? Which case?
148 counter is filed, Milord, none appears. 149, 150 counter is filed, Milord.
149 and?
150, both times it was served, none appeared, Milord. And another two matters, Milord, it was returned unserved again, Milord.
No, other one is only 151, right?
Yes, Milord.
So 151, what is the position? None appears.
Yeah, they were again served with notice, Milord. Again, it is returned, Milord. Two times also.
Returned back served, no?
Returned unserved, Milord.
Unserved. Then you have to take steps for by publication or whatever.
Yes, Milord. Next time I will take, Milord. As far as 148 is concerned, your Lordship may appoint 149, 150.
Yes. So, yes, Mr. Which is the agreement dated?
The agreement is dated 19/5/2021, Milord.
19/5/21. What is the clause for dispute resolution?
Clause is 10.13.2, Milord.
10?
10.13.2, Milord. Sole arbitrator. Notice was sent on 25/4/2022, Milord.
25?
4/2022, Milord.
22. All right.
Yes, Milord.
Yes, madam. This petition under section 11 within bracket 6. In this petition under 11 within bracket 6 of the Arbitration Conciliation Act, petitioner seeks appointment of an arbitrator. Paragraph facts giving rise to filing of this appeal briefly stated are that parties entered into an agreement and on 19/5/2021. You say none for respondent, those served in the beginning. Parties have entered into an agreement on 19/5/2021. The clause 10.13.2 contains a mechanism for dispute resolution by way of an arbitration. The aforesaid clause reads as under page 39, paragraph D.
The 15th of September.
He is not filing. You argue.
We
have filed counter, my lords.
Oh.
My lords, the counter was filed yesterday.
So.
And on 8/9, my lords had given a direction stating that.
Fine. So we are taking it on record. Despite that, what is there? The idea is to decide it in a time-bound manner. Right?
Then my lords will
Yes.
grant us some time because they filed
Yes,
a 100-page document, your lordships. And we.
Right, counsel for the petitioner submits that the copy of counter filed on behalf of respondent has been served on her only whatever yesterday's what date 21st September 2023. She prays for a short accommodation to enable her to go through the same list on 29th September.
My lords may grant us 2 weeks' time. My senior is traveling, my lords.
Best opportunity to argue, madam. Let the senior travel. He is senior, that's why he is traveling, and you become senior by arguing, right? 6th October 23.
Much obliged.
My lord, so I am appearing for the respondent in this matter, my lord. I have filed my counter.
Yes.
I have already filed my counter, my lord. I am making only one objection, my lord, with respect to the purchase order. Which according to the Supreme Court, recent Supreme Court judgment, my lord, it requires the stamp duty to be paid. This purchase order is which attracts the stamp duty.
What is we will hear you next Friday, Mr.
Your Lordship, if I may, Your Lordship, the case law relied by the respondent in this counter he has given a very specific reading of the judgment, Your Lord.
Counter has there, madam? Yes. Yes. So we will hear him on next date.
We require 2 weeks, Your Lordship, because
So he is praying for 2 weeks' time.
yes, Your Lordship.
The counter has been filed on behalf of the respondent, learned counsel for the petitioner, prays for adjournment in order to enable him to argue the matter list after 2 weeks. Yes.
What's your place?
Sir, beg to appear for respondents number 6 and 7, my lords. We have entered appearance today, my lords. My lords may kindly give 2 weeks time, my lords. We'll file a counter and then.
Your Lordship, I appear for respondent
This
one
is just
and
a
two.
formal application to issue the previous arbitrator whose mandate should lapse by operation of section 29A.
Lords, in fact, I'm handicapped by the application also, my lords. I'm a new counsel, my lords. The counsel, Mr. Kishore, or learned counsel, senior counsel Kishore, my lords. I'm not appearing for them also. New counsel.
Next, 22nd, 29th.
Your Lordship, 2 weeks time will be granted. I am appearing for R1
Hey,
and
madam. Again, same thing. Senior counsel said something, right? Did you not hear him?
we'll file a formal
Whatever,
reply
yes.
also, Your
No.
Lordship.
Learned counsel for respond. What's your, for whom you are appealing?
R1 and R2, Your Lordship.
R1 and R2 and learned counsel.
6 and 7.
6 and 7 pray for short accommodation to enable them to seek instructions and to file counter if so advised list on 29 September.
Lordship, kindly 2 weeks, Your Lordship.
No, madam, you do it. What is there, 29 September?
May I file application for seeking extension of time. Seeking extension of time before the arbitrator for concluding the proceedings.
Yes, for the reasons assigned in after hearing learned counsel for the parties and for no 23 is allowed.
My lord, this notice was sent to respondents.
What happened?
1 to 4 respondents return answer. Response was 2 weeks time have to take submission. And now this again.
Learned, to whom it has been received?
Return answer.
Office, postal office report indicates that notice issued to respondent number 1 to 4 has been received back unserved. Unserved. In view of aforesaid office note, learned counsel for the petitioner, prays warrant is granted 2 weeks time to enable her to take steps for service of notice on respondents 1 to 4, then personal notice, proof of service, right? List after 2 weeks.
My lord, may I make a mentioning?
Yes.
My lord, there is an arbitration application section 11.6 which is not listed today, but it was supposed to be listed on 18th.
Yeah, Mister, you should have said in the, all right, next Friday it comes up, 29th.
Lord, kindly grant me a particular date. My lord, 29th September.
That's what we are saying, right?
Yes, my lord. My lord, my
You
associate is
should
standing.
not mention at the beginning of the proceeding, that's what we are saying. What is the number? Any memo, right? No memo, nothing orally. Your colleague. You give the memo.
APPL 119/2023.
Give it 29th. 29th.
Obliged, my lord.